Q. 55. What are the amicable means of settlement of international disputes? Ans. The method of the settlement of international disputes may be divided into two main categories. 1. Pacific means of settlement, and 2. Compulsive or forcible means of settlement. Pacific means of settlement of international disputes. Following are the pacific means of settlement of international disputes. 1. Arbitration. By arbitration we mean the method through which a dispute is referred to certain persons called arbitrators. Their decision is known as the award. These arbitrators are selected by the parties to the dispute. Although they are selected or appointed on the basis of the consent of the parties to a dispute, their decision or award is binding upon the parties. The history of settlement of international disputes through arbitration may be traced from very ancient times. But in modern times its history dates back from the Treaty of 1794 between England and America. The next important event in the development of settlement of international disputes through arbitration was Alabama Claims Arbitration, 1872. In this case, America had claimed compensation from Britain on the ground that it had violated the laws of neutrality. The arbitrators gave their award in favor of America and held that Britain was liable to pay compensation. As remarked by Judge Hudson, the success of Alabama Claims Arbitration stimulated a remarkable activity in the field of international law decisions. Kutch Arbitration Award, 1968. It will be desirable to mention here briefly the facts and circumstances which led to the Kutch Arbitration Award, 1968, and the details of the award. The Run of Kutch is a place on the border of Gujarat and West Pakistan. There was a dispute between India and Pakistan in regard to some land in the Run of Kutch. Pakistan claimed 3,500 sq miles of the said land. This led to the armed conflict between the two countries in 1965. After the ceasefire, both India and Pakistan agreed to refer this matter to arbitration. One arbitrator, Albase Beber of Yugoslavia, was nominated by India. The other arbitration, Nasrullah Entizam of Iran, was nominated by Pakistan, and the third was to be nominated with the mutual agreement of both the states. Since India and Pakistan could not agree upon a third arbitrator, on the request of both the countries, Judge Gunnar Lagajaran, the chairman of the arbitral court, was nominated by the Secretary-General of the United Nations. The arbitral court gave its award on 19 February 1968. According to the award, 320 sq miles I, about 10% of the Pakistani claim of the land belonged to Pakistan and the rest belonged to India. It is one of the well-recognized principles of international law that the award of an international arbitral court is binding upon the parties. Consequently, India accepted and implemented it. 2. Judicial settlement. Thus the International Court of Justice has rendered signal service for the development of international law. However, the court has its own limitations. Its decisions have no binding force except upon the parties to a dispute and only in respect of particular dispute between them. 3. Negotiations. Negotiations are also the means for the settlement of international disputes. It is a much less formal method than judicial settlement. Sometimes disputes are settled only through negotiations. But if negotiations fail to resolve the dispute, then other method, such as good offices, mediation, etc. may be used along with negotiations. 4. Good offices. When two states are not able to resolve their disputes, a third state may offer its good offices for the same. These offices may also be offered by international organizations or some individuals. The third state, individual or international organization creates such an environment as may be conducive for the settlement of the disputes. Some general suggestions may also be put forward, but the third party does not take active part in the negotiations. 5. Mediation. Mediation is yet another method through which efforts are made to the settlement of international disputes. In the case of mediation, the third state or individual not only offers its services, but also actively participates in the talks to resolve the dispute. 6. Conciliation. In wider sense, conciliation is a method through which the other states or the impartial persons try to resolve the dispute peacefully through different means. After the matter is referred to a commission or committee which submits its report and recommends certain measures for the settlement of disputes. These proposals are, however, not binding upon the parties. In the words of Judge Hudson, conciliation is a process of formal proposals of settlement after an investigation of the facts and an effort to reconciliate to accept or reject proposals formulated. The Hague Conventions of 1899 and 1907 made the provisions for a conciliation commission. In the present time also conciliation is adopted as a method of settlement of an international dispute. A recent example of this is the 1965 Convention on the Settlement of Investment Disputes between States and the nations of other states, which provides for conciliation commission for the settlement of dispute. 7. Enquiry. Enquiry is also a method which is often resorted to for the settlement of disputes. It may be noted that it is not an independent method and is often applied along with other methods. The main objective of the inquiry is to make investigation of the relevant matters so as to establish facts which may hold the ultimate solution of the problem. For example, often inquiry commissions are appointed in relation to the settlement of border disputes. The commission clarifies the facts after making inquiry into the relevant facts. 8. Settlement of international disputes under the auspices of the United Nations Organization. Briefly speaking, following are some of the provisions for the United Nations Charter. It is one of the purposes of the United Nations that the member states settle their disputes through peaceful means. Under Article 2 of the Charter, the member states have undertaken to resolve their disputes through peaceful means and not to resort to force or threat of force to resolve international disputes. 2. The General Assembly of the United Nations may make recommendation for the peaceful settlement of international disputes. Article 14. 3. Articles 33 to 38 of Chapter 6 of the Charter make the provisions for the peaceful settlement of international disputes. Q. 56. What are the compulsive means of settlement of international disputes? Ans. If the states are not able to solve their disputes through peaceful means, they resort to compulsive or coercive means, which are as follows. 1. Retorsion. When a state behaves in a discourteous manner with another state, then international law confers right upon the state affected to resort to retorsion. The word retortion means retaliation. But the affected state can take only those means or measures as retortion which are otherwise also permitted under international law. For example, in retortion, diplomatic relations may be ended, privileges of diplomatic agents may be withdrawn, and economic facilities may be stopped. As rightly pointed out by Stark, the United Nations Charter has to some extent affected the right of retortion because in accordance with the provisions of Charter no state can take any action in the form of retortion as may endanger international peace and security. 2. Reprisal. Another compulsive means of settlement of international disputes adopted by one state against another for the purpose of settling some dispute brought about by the latter's illegal or unjustified act. In the case of Nollila Incident, Special Tribunal, Germany v. Portugal, 1928, to Araye 1012, 1019, the tribunal held that the right of reprisal is subject to the following restrictions. A. Reprisals are illegal unless they are based upon a previous act contrary to international law. B. There must be a certain proportion between the offense and the reprisal as a necessary condition for the legitimacy of the latter. C. Reprisals are legitimate only when they have been preceded by an unsuccessful demand of redress. In fact, the employment of force is justified only when it is necessary. Recent example of the use of this means for the settlement of the international dispute is the Israeli action in bombarding certain areas of Lebanon from where the Arab guerrillas operated attacks from time to time in different parts of the territory of Israel. United Nations Charter has greatly affected the right of the states is to resort to reprisal. No state is entitled to reprisal which may endanger international peace and security. 3. Embargo. Embargo is yet another compulsive means for settlement of international disputes. It is a type of reprisal. By embargo we mean that if a state violates international law or commits some international crime, then the affected state becomes entitled to create obstruction in the transport of its ships which are within the territory of the affected state. 4. Pacific blockade. Pacific blockade is yet another compulsive means of settlement of international disputes. Through Pacific blockade, the ingress and regress of the ports of the states are blockaded so that the ships of other states may not reach those ports, and the shops of the blockaded state may not go out of the ports. However, there is a distinction between Pacific blockade and a blockade which is used in peacetime. It is often resorted to as a reprisal because through blockade of the ports of a state, that state may be compelled to settle its disputes. 5. Intervention. Intervention is a dictatorial interference by a state in the affairs of another state for the purposes of maintaining or altering the actual conditions of things. In principle, international law prohibits intervention. 6. Under the auspices of the UN, Chapter 7 of the Charter of the UN deals with the provisions under which the Security Council can resort to compulsive means for the settlement of disputes regarding maintenance or restoration of international peace and security. These provisions have been discussed in Chapter on the Security Council. Please therefore see the chapter on Security Council for a discussion of these provisions. Q. 57. Differentiate. A. Good offices and mediation. B. Retorsion and reprisal. Ans. A. The main distinction between good offices and mediation is that in case of good offices, the third party simply offers its services and does not actively participate in the talks, whereas, in the case of mediation, the third party actively participates in the talks and makes suggestions so as to resolve the dispute between the state. A good example of mediation and good offices is that of Tashkent Agreement in the end of 1965 and beginning of 1966, wherein Russia succeeded in bringing about an agreement between India and Pakistan. Ans. B. The main distinction between reprisal and retorsion is that while in retorsion only that action can be taken which is permitted under international law and depends upon the discretion and sweet will of the states, whereas in reprisal those actions can also be taken which might otherwise be illegal but are allowed as reprisal in certain special circumstances. As pointed out by Stark, reprisal consists of acts which would generally otherwise be quite illegal, whereas retorsion consists of retaliatory conduct to which no legal objection can be taken. Q. 58. What do you mean by the term war? What are its immediate effects? Ans. Definition of war. According to Hall, when difference between states reach a point at which both parties resort to force or one of them does acts of violence which the other chooses to look upon as a breach of peace, the relation of war is set up, in which the combatants may use regulated violation against each other, until one of the two has been brought to accept such terms as his enemy is willing to grant. Effects of outbreak of war. 1. General effects. Besides affecting neutral states, war mainly affects the belligerent states. According to Oppenheim, it is wrong to say that due to outbreak of war, all the relations of the belligerent states and of their citizens came to an end, although limitations and prohibitions and the relations of the belligerent states during war are governed by the laws of war. 2. Diplomatic and consular relations. At the outbreak of the war, the diplomatic and consular relations between the belligerent states are broken immediately. Consequently, the belligerent states recall their diplomatic agents from each other. Often at the outbreak of war, the receiving belligerent states hands over the passport to the diplomatic agents of the enemy country, which means that they should immediately return to their home states. In this connection, Article 44 of the Vienna Convention on Diplomatic Relations 1961 provides that it is the duty of the receiving state to provide necessary facilities to such agents so that they may return safely to their home state. 3. Treaties. According to the old view, all treaties are terminated between the belligerent states after the outbreak of war. In the present times, many significant changes have come in this respect. The present practice of the states shows that all the treaties between the belligerent states do not come to an end. Some treaties are completely terminated, some remain in force, while some others are simply suspended during war times. 4. Trading and intercourse in commerce. All trading and intercourse between the belligerent states are prohibited during the war. It is a well-recognized rule of international law that the treaties relating to trading and intercourse between the belligerent states stand terminated at the outbreak of war. 5. Contracts. The effect of the contracts at the outbreak of war between belligerent states is a matter of municipal law rather than that of international law. Consequently, belligerent states are free to make rules and to enforce them in accordance with the contracts. International law leaves them free to make necessary laws regulating the validity or invalidity of contracts at the outbreak of war. The practice of the states, however, shows that the executory contracts become completely invalid, whereas executed contracts remain unaffected at the outbreak war. 6. Enemy property. Enemy property may be of two kinds: public enemy property and private enemy property. I. Public enemy property. At the outbreak of war, all movable public enemy property situated in the enemy state may be seized. The position in regard to the immovable public enemy property is, however, different. Immovable may be temporarily taken but cannot be permanently seized. After the outbreak of war, it is determined as to what should be done in regard to this property. Consequently, the sale or disposal of immovable public enemy property is not possible during war. It can only be used by the belligerent state during war. 2. Private enemy property. The practice of the states shows that private enemy property situated in the territory of the belligerent state may be taken over for a temporary period. After the end of the war, its fate is decided in accordance with the provisions of the peace treaty concluded, if any, between the belligerent states. The belligerent state is not entitled to seize the private enemy property, but can only take it if it is necessary for local needs. There are, however, certain exceptions in this connection. The rules of international law mentioned above are not applicable in case of enemy ship in the sea. The ships of enemy, whether they are public or private, can be seized during war. 7. Combatants and non-combatants. Under international law, the soldiers of the belligerent states are divided into two categories: lawful and unlawful. At the outbreak of war, lawful soldiers can be killed, grievously hurt, arrested, or made prisoners of war. Lawful soldiers are ordinarily those soldiers who are in the regular army. Unlawful combatants, however, enjoy certain facilities or concessions. They may also be arrested and made prisoners, but they cannot be killed or grievously hurt during war. Q. 59. Define total war. Ans. Total war. In accordance with the traditional definition of war, war is a contest between the armed forces of the belligerent states. Its object is to overwhelm the enemy and impose conditions upon the enemy. As pointed out earlier, this definition has become inadequate in view of the scientific developments and development of destructive weapons in the modern times. In the modern time, war not only affects the armed forces but also the civilian, and the nature of the war is such that observance of the rules of war becomes impossible. Such a war has, therefore, been called total war. The term total war was first used by Grotius. In this view, 30 Years' War of Europe was total war. According to Joseph L. Kunge, the religious wars of 16th and 17th centuries were fought with such cruelty and barbarity that they can be called total wars. Q. 60. What factors determine the enemy character of 1. Individuals, 2. Corporations, 3. Ships, 4. Goods. Ans. Immediately after the outbreak of war between the states, a significant change comes in their relations. States bring about changes in their behavior against the enemies in accordance with the objectives. States determine their behavior or treatment in accordance with the enemy character of the individual, goods, corporations, ships, etc. Therefore, in order to regulate their activities and behavior, it is necessary to determine the enemy character of individuals, goods, corporations, etc. Once the enemy character of individuals, goods, corporations, etc. is determined, the belligerent states regulates its behavior towards the enemy state accordingly. From the practice of the states and the rules that have been formulated so far, we can derive the following conclusions. 1. Enemy character of individuals. Enemy character of individuals can be studied under the two headings. A. Enemy character of individuals of the belligerent states, and B. Enemy character of the individuals of neutral states. A. Enemy character of the individuals of the belligerent states. In regard to the enemy character of individuals, there is no uniformity in the practice of different states. They determine the enemy character of individuals of belligerent states in accordance with the different tests and standards. For example, in Britain and America, the enemy character is determined on the basis of their residence and domicile. On the other hand, enemy character of the individuals in the continental countries, European countries excepting England, is determined on the basis of their nationality. In other matters, there is hardly any difference in practice of Britain and America on the one hand and continental country on the other hand. B. Enemy character of individuals of neutral states. The individuals of the neutral states who do not reside in the territory or enemy state are not deemed to be having enemy character. But if they participate in activities against the belligerent state, then they may be deemed to having enemy character. Similarly, in accordance with the practice prevailing in America and England, if the individuals of the neutral state carry goods, etc., to the enemy state or territory or continue intercourse with them, then they will be deemed to be having enemy character, or in other words, they will be treated as enemies. But the citizens of the enemy still living in neutral states will not be deemed to be having enemy character. 2. Enemy character of corporations. The enemy character of corporation can be determined mainly by the following two things. A. Their permanent residence, and B. Their registration. If a corporation is registered in enemy state, then it will be deemed to be having enemy character. Similarly, the enemy character of the corporation is also determined by its permanent residence. By a permanent residence of the corporation means its existence and conduct of business. In regard to the enemy character of corporations, the leading case is Daimler Co. Limited v. Continental Tire and Rubber Co. Limited, 1916, 2 AC 307, wherein important principles were propounded. In this case, the most important principle that was propounded was that if the persons or agents of the corporation who are in de facto control of the company reside in the enemy state or territory, then the company shall be deemed to be having enemy character. 3. Enemy character of ships. The enemy character of ships is determined by their flags. This rule was adopted in Declaration of Geneva, 1909. By the flag of the ship is meant flag which the ship is legally authorized to use. For example, if a ship of France uses the American flag, then it will be unauthorized. If the ship of an enemy state unauthorizingly uses the flag of a neutral state and is seized by the belligerent state, then such a ship shall be deemed to be having enemy character. Consequently, those ships which use the flags of neutral states but are actually under the ownership of the enemy state may assume enemy character under the following circumstances. I. If the ship is in the service of enemy state or carries arms or takes part in the conflict. 2. If the ship resists the valid right of the belligerent state to visit and search, then such a ship may be seized and it may be deemed to be having enemy character. If such a ship is seized, the onus, burden, of proving rests on the owners of the ship that the ship belongs to neutral state. If it is not proved, then the ship and its cargoes are deemed to be those of enemies. 4. Enemy character of goods. Originally, enemy character of the goods is determined by their ownership. If the owners of the goods are residents of the enemy state, then the goods may be deemed to be having enemy character. On the other hand, if the owners of the goods live in neutral state, the goods will not be deemed to be having enemy character. Different countries have modified and amended this rule in accordance with their convenience and needs of times and circumstances. But the general rule which is evident from the general practice of the states is that the enemy character of the goods is determined by the ownership of the goods. 5. Transfer of goods in sea. If the sale of the goods takes place before war or without its consideration, state law is applied to determine whether the transfer of ownership has been effected. If the change in ownership is attempted during war or in view of the war, the goods are deemed to be of enemy character, and such goods are not considered to be the property of neutral state and may be confiscated. Q. 61. A joint stock company was formed in 1905 and has its registered office in London. The company was framed for the purpose of selling in the UK motor tyres made in Germany by a company incorporated in that country under German how. The German company held more than 90% of shares in the company in question, and all the directors were German subjects. Only one of the shareholders was a British national. During the First World War, the question arose whether the assets of the company were enemy property. How would you decide this question? Ans. On the facts stated above, it was held in Daimler Co. Limited B. Continental Tire and Rubbers Co. Limited that the assets of the company were enemy property. The following principles of law were laid down in the above case. 1. The enemy character may be assumed by a corporation if its agents or the persons in de facto control of its affairs are resident in an enemy country, or wherever resident, are adhering to the enemy or taking instructions from or acting under the control of enemies. 2. A company incorporated in the United Kingdom could, as such, be neither friend nor enemy, yet such a company could only act through its agents, and these might assume an enemy character in time of war when they were resident in the enemy country or were acting under the instructions of enemy shareholders. 3. The character of individual shareholders cannot, of itself, affect the character of the company. It depends on the question whether the company's agents, or the persons in de facto control of its affairs, are in fact adhering to, taking instructions from, or acting under the control of enemies. 4. A company registered in the United Kingdom but carrying on business in a neutral country through agents properly authorized and resident here or in a neutral country is prima facie to be regarded as a friend, but may through its agents or persons in de facto control of its affairs assume an enemy character. 5. A company registered in the United Kingdom but carrying on business in an enemy country is to be regarded as an enemy. Q. 62. The law of war is based on usage hardened into customary law and modified from time to time by lawmaking treaties. Examine this statement adverting to rules of land warfare. Ans. Rules of land warfare. The laws of war, which had their origin in custom and convention, have undergone rapid changes in recent times. The preamble to the Hague Convention 4 of 1907 declared that population and belligerents remain under the protection and rule of the principles of the law of nations as they result from usages established between civilized nations, the law of humanity and the requirements of the public conscience. The existing laws and customs of war are mostly regulated by customary and conventional law. The savage cruelty and ruthlessness with which wars in early times were fought and the great miseries that these wars brought led thinkers and philosophers to formulate rules to regulate the conduct of war, which they found impossible to abolish. The development of the laws of war began in the Middle Ages, under the influence of the Christian ideals of humanity and chivalry. Since then the rulemaking process has been going on through the agencies of conference, conventions, treaties and through the persuasive writings of thinkers and jurists. Gradual development influenced by the principles of humanity, morality and chivalry witnessed great progress in the development of the laws of war because of the occurrences of huge political upheavals and because of the Great War that shook Europe. The Declaration of Paris, 1856, the Geneva Convention of 1864, the Declaration of St. Petersburg of 1868, and the Convention relating to the laws of war on land as a result of the First Hague Conference of 1899 are the most important general treaties which helped the development of the laws of war during the latter half of the 19th century. By the end of the 19th century, an elaborate body of customs and usages of war found place in the works of eminent leading jurists, but the law in certain respects was uncertain and doubtful and needed classification. The important agencies of development of laws in the 20th century were the general treaties that were concluded under the auspices of the Hague Conferences. The merit of these Hague Conventions lies in their classification of the uncertain customary rules of war that already existed. Some of these conventions were expressed to be binding only in wars while the signatories to the convention were the belligerents, and thus they provided a loophole for evasion of rules laid down therein. But in spite of this general participation clause, states in general regarded them to be binding, and the British courts held them to be valid. The Nuremberg International Tribunal in 1946 expressed the view that those conventions embodied rules of customary law. The failure of several states to ratify some of these Hague Conventions did not affect their validity and binding force. They are now well recognized as embodying customary laws of war. The First World War with its new weapons of destruction found many of the rules of war inapplicable, and the result was that belligerents felt themselves free in many respects in their conduct of the war. In consequence, many of the rules of war perished under the stress of new conditions of warfare. Only a few survived. In the presence of the League of Nations with its system of collective security, the effort to revise and to formulate new rules of war took a concrete shape in the Washington Conference of 1921. The appearance of the Pact of Paris and other international attempts to abolish war did not allow the conference to reach a final agreement on the subject. Then came the Second World War, which shattered many established traditional rules of war, and the principle of military necessity found its widest scope. After the Second World War, the majority of states met at the Geneva Conference and concluded a final act in 1949 for the protection of war victims. The development of the laws or land warfare may be traced through the following general treaties. 1. Geneva Convention, 1864. The Geneva Convention of 22nd August 1864 for the amelioration of the condition of wounded soldiers in armies in the field. 2. St. Petersburg Declaration. The Declaration of St. Petersburg of 11th December 1868 prohibiting the use of any explosive or charged with fulminating or inflammable substances. 3. Hague Conventions of 1899 and 1907. The Hague Conventions of 1899 and 1907 concerning expanding, dundum, bullets, projectiles, and explosives launched from balloons, projectiles diffusing, asphyxiating or deleterious gases, concerning the opening of hostilities, and concerning the rights and duties of neutral powers and persons in land warfare. Article 23 of the Hague Convention of 1907 forbade improper use of flag of truce, of the national flag or of military insignia and uniform of the enemy as well as the distinctive badges of the Geneva Convention. It also forbade killing or wounding an enemy who laid down his arms or surrendered at discretion having no longer his means of defense. Non-combatants were made exempt from personal injury, except in so far as it resulted incidentally in the course of the lawful operations of warfare, or was inflicted as a punishment for offences committed against the invaders. Article 25 prohibited the attack or bombardment by any means whatsoever of undefended cities, villages, and buildings. Article 23 of the Hague Regulations forbade a belligerent to compel subjects of the other side to take part in the operations of war directed against their own country, even if they were in his service before the outbreak of hostilities. 4. Treaty of Washington. By Article 5 of the Treaty of Washington, 1922, the signatories agreed to prohibit the employment in war of asphyxiating, poisonous or other gases, and all other analogous liquids, material or devices. 5. Protocol of 1925. The Protocol of 1925 concerning the use in war of asphyxiating, poisonous and other gases. 6. Geneva Conventions, 1929. The Geneva Conventions of 1929 concerning treatment of the sick, wounded and prisoners of war. 7. Geneva Conventions, 1949. 4 conventions were concluded at Geneva in 1949 relating to 1. The treatment of prisoners of war. 2. The amelioration of the condition of the wounded and sick in armed forces in the field. 3. The amelioration of the condition of the wounded, sick and shipwrecked members of armed forces at sea. And 4. The protection of civilian persons in time of war. Q. 63. What are the prohibited means of warfare? Ans. Prohibited means of warfare. That the belligerents do not possess an unlimited right to injure their opponent has been recognized by the Fourth Hague Convention, 1907. Article 23 prohibited instruments of warfare of a destructive or painful character, prohibited the use of poison or poison weapons and employment of arms, projectiles, or material calculated to cause unnecessary suffering and forbade the discharge of projectiles and explosives from balloons and by other new methods of a similar nature. The use of projectiles, the sole object of which was diffusion of asphyxiating and deleterious gases, was also abstained. It was also prohibited to use expanding, dum-dum, bullets. Article 23 forbade improper use of a flag of truce, of the national flag, or of military insignia and uniform of the enemy, as well as the destructive badges of the Geneva Convention. It also forbade killing or wounding an enemy who laid down his arms or surrendered at discretion, having no longer his means of defense. Non-combatants were made exempt from general injury, except in so far as it resulted incidentally in the course of the lawful operations of warfare or was inflicted as punishment for offences committed against the invaders. Article 25 prohibited the attack or bombardment by any means whatsoever of undefended cities, villages and buildings. Article 23 of the Hague Regulations forbade a belligerent to compel subjects of the other side to take part in the operations of war directed against their own country, even if they were in his service before the outbreak of hostilities. The St. Petersburg Declaration, 1868, prohibited the use of any projectile of a weight below 400 grams, which was either explosive or charged with fulminating or inflammable substances. The Hague Conference of 1899 adopted declarations renouncing the use of expanding bullets and the use of projectiles, the sole object of which is the diffusion of asphyxiating and deleterious gases. By Article 5 of the Treaty of Washington, 1922, the signatories agreed to prohibit the employment in war of asphyxiating, poisonous or other gases, and all analogous liquids, material or devices. Q. 64. A. Who are prisoners of war and how are they to be treated? Discuss the provisions relating to repatriation of war prisoners and refer to Korean and Pakistani war prisoners. B. Write a short note on the treatment of the sick and wounded combatants in land warfare. Ans. A. Prisoners of war. Prisoners of war are those soldiers who are captured by either of the belligerents in time of war. Sir Robert Fillimore enumerates the following classes of persons having no claim to the treatment of prisoners of war. 1. Bands of marauders, acting without the authority of the sovereign or the order of the military commander. 2. Deserters, captured among the enemy's troops. 3. Spies, even if they belong to the regular army. The laws of war provide for the execution of spies when found by a commander within the lines of his army, or giving information of his plans and movements to the enemy. Their treatment. Prisoners of war must be cared for and treated with humanity. The captor may employ private soldiers, not officers, in useful work, not in any way connected with the operations of the war. The work should also not be excessive. In all cases, they must be paid for their work. Non-commissioned officers under the Hague Convention of 1949 are only required to do supervisory work, but they may ask for other work. According to the regulations of 1907, prisoners are to enjoy complete liberty of worship. They may be released on parole if the laws of the country permit that procedure. Prisoners caught in an attempt to run away may be shot in the last resort. If they are captured, they may be punished. The Hague Conferences of 1899 and 1907 charged each belligerent with the task of establishing an information bureau in its territory and sending the necessary information to the government of the other belligerent after the termination of hostilities. The Geneva Convention of 1929 also made provisions for the treatment of prisoners of war. As between the ratifying states, the convention replaced those of 1864 and 1906. One of the conventions concluded at Geneva in 1949 related to the treatment of prisoners of war, which applies to any armed conflict recognized or unrecognized arising between the contracting parties. The convention prohibits violence to life and person of prisoners, taking of hostages, and humiliating or degrading treatment. No physical or mental torture is allowed to be inflicted on prisoners to compel them to give information. After capture, they have to be removed from the danger area. Captivity may be terminated by repatriation, accommodation in neutral countries, release, escape, or death of the prisoner. Korean War prisoners. In the Korean War, the main obstacle to armistice was the repatriation of war prisoners. The Communists demanded wholesale repatriation of North Korean and Chinese prisoners of war to Communist territory on the basis of Arts. 118 and 119 of the Geneva Convention relating to the treatment of prisoners of war, 1949, which provides for the unconditional handing over of the prisoners to the authorities on whose behalf they came to fight without delay after the cessation of active hostilities. The United Nations negotiators objected to forced repatriation of unwilling prisoners to the Communists. The truce agreement signed on 27 July 1953 provided that prisoners not willing to return to their land would, in the first instance, be placed into the care of a neutral commission. The prisoners who were unwilling to return to North Korea or China were ultimately screened and dispersed after release. Pakistani war prisoners. The provisions of the Geneva Convention, 1947, lay emphasis on the release of civil internees, while in the case of military prisoners of war on their repatriation. In the case of military prisoners of war, who in the present case constituted 93,000 imprisoned in India during 1971 Indo-Pakistan War, the Geneva Convention does not enjoin automatic repatriation. The phrase cessation of active hostilities used in Art. 118 of the Convention means not the suspension of hostilities in pursuance of the ordinary armistice, which leaves open the possibility of a resumption of the conflict, but a cessation of hostilities so as to render a resumption of hostilities highly improbable. Q. 65. Distinguish between stratagem and deceit as understood in the law of war. To what extent is either of these legitimate? Illustrate your answer by examples. Ans. Stratagem. According to Lawrence, stratagems are rules practiced on the enemy in order to mislead him and put him off his guard. That they may be used at all is due to the fact that war is a conflict of its quite as much as a conflict of arms. Article 24 of the Hague Regulations permits ruses of war and the employment of methods necessary for obtaining information about the enemy and the country as lawful. Stratagems that do not violate any express or tacit understanding between the belligerents are perfectly lawful and legitimate, as every general is expected to guard against them by his own vigilance and prudence. Stratagem and deceit. Halleck distinguishes between stratagem and deceit, which he calls perfidy, by observing that, whenever a belligerent has expressly or tacitly engaged, and is therefore bound by moral obligation to speak the truth to an enemy, it is perfidy to betray his confidence, because it constitutes a breach of good faith. Thus, for example, stratagems must not be applied where the enemy had been taken off its guard by any of the recognized signs, such as a flag of truce or the Red Cross emblems, of a desire to establish communication or enjoy immunity from attack, nor should they be resorted to in connection with the carrying out of capitulations, which must be done to the letter. Assassination of enemy generals, soldiers or heads of the states, as also the feigning of surrender with the ultimate desire to entrap the enemy are all sheer perfidies and must not be looked upon as stratagems. The laying of ambushes and traps, the concealing of military operations through false marches, erection of barriers, etc., the feigning of attacks, or flights or withdrawals are examples of bona fide ruses of war. Use of pretended signals or the use of the enemy's watchword and giving wide publicity to deceitful intelligence are further examples of ruses of war. Troops engaged in actual conflict must not wear the uniform or carry the ensigns of the enemy. Article 23 of the Hague Regulations forbids belligerents from the improper use of the national flag or of the military insignia or the uniform of the enemy. A stratagem may be retaliated by a stratagem. Thus, as Lauterpact observes, if a spy of the enemy is bribed to give deceitful intelligence to his employer, or if an officer, who is approached by the enemy and offered a bribe, accepts it feigningly, but deceives the briber and leads him to disaster, no perfidy is committed. Q. 66. Discuss the legality or otherwise of espionage, war treason, ruses and stratagems during the conduct of hostilities between two belligerents. Ans. Espionage. The use of spies in time of war was a measure of recognized legality notwithstanding the severe penalty inflicted upon the spy if caught by the enemy. In international practice, however, difficulties arose from lack of a sharp distinction between spies, scouts, dispatch bearers, and war traitors. The Hague Regulations of 1899 followed the customary law in making the escape of spying to consist in acting clandestinely or on false pretenses with the object of obtaining information in the name of operations of a belligerent and of communicating it to the enemy. It was further provided that soldiers not in disguise, properly known as scouts, might penetrate the enemy's lines to obtain information without being considered spies. So also dispatch bearers, whether soldiers or civilians, were not considered spies if they carried out their missions openly. Persons sent in balloons to deliver dispatches or maintain communications between different parts of the army or territory came within the same category. Upon the outbreak of the Russo-Japanese War, Russia announced the intention of treating as spies war correspondents who should communicate news to the enemy by wireless telegraphy, but the threat was not carried into effect. The regulations provided for the trial of spies before punishment, and they emphasized the legality of the use of spies by providing that a spy who had escaped and was afterwards captured was to be treated as a prisoner of war. The American rules of land warfare emphasized the customary rules that no distinction of sex was made in respect to the penalty inflicted upon spies. War treason. A difficult problem of military occupation during both world wars that arose was what is technically known as war treason. The Hague Regulations forbade the military occupant to compel the population to take the oath to the hostile state, but it was well established by customary law that individual citizens must refrain from communicating in any way with the armies of their own country and from giving them other aid and comfort. Customary law recognized that war traitors might be severely punished and the death penalty imposed for betraying information concerning the condition or operations of the occupying army. Ruses and stratagems. Ruses of war are stratagems employed with a view to misleading the enemy in its military operations. Article 24 of the Hague Regulations does not disallow the employment of ruses of war for the purpose of deceiving the enemy. Laying of ambushes and traps, masking of military operations, the feigned of attacks, or withdrawal afford examples of legitimate ruses of war. Q. 67. Discuss the rules or international law in regard to enemy occupation. Illustrate your answer by reference to some justified and unjustified events in the two world wars. Ans. Enemy occupation. Occupation is completed by taking possession of the territory and establishing an administration over the same in the name of the occupying or acquiring state. Article 42 of the Hague Regulations attached to the Fourth Hague Convention of 1907 declares that a territory is said to be occupied when it is actually placed under the authority of a hostile army, and that such occupation is effective only when it is supported by a force sufficient to maintain the authority of the occupant. The inhabitants of the occupied territory are under the military control of the occupant and have to render obedience to his commands. Article 43 of Hague Regulations declares that the occupant shall take all steps in his power to re-establish and ensure, as far as possible, public order and safety while respecting, unless absolutely prevented, the laws in force in the country. The Hague Regulations forbid the occupant to compel the population of the occupied territory to take an oath of allegiance to the hostile power, but permit him to demand from them an oath of neutrality as also an oath to give the same obedience and loyalty though temporary as the lawful sovereign was entitled to. The occupant cannot compel the inhabitants of the occupied territory to give him information about their own troops. Article 56 of the Hague Regulations expressly forbids the seizure or destruction of institutions dedicated to public worship, charity, education, science, and art. Historical monuments and works of art or science are likewise to be protected. Immovable property, as a general rule, is incapable of appropriation by an invader. It is bound up with the territory. The profits arising from them are free from confiscation, and the owners are to be protected in all lawful use of them. Article 45. But troops may be quartered in private houses, though the inhabitants may not be ejected from their homes to make more room from the soldiery. Moreover, the need of actual conflict may justify the destruction of buildings or the use of them as fortified posts. Article 53 gives immunity to movable property of the non-combatant population of occupied districts from its seizure unless it consists of arms, war material, etc. Private property has to be respected and cannot be confiscated. Art. 46. Pillage of private property is strictly forbidden. The invader, however, can use neutral property found in the occupied territory on payment of proper compensation. Article 54 provides that submarine cables connecting an occupied territory with a neutral territory are not to be seized or destroyed except in the case of absolute necessity. In the latter case, they are to be restored at the conclusion of peace, and indemnities paid for them. The invader, under the Hague Regulations, can punish severely acts falling under war treason. Article 52 of the Hague Regulations forbids the occupant to compel the nationals of the hostile party to take part in the operations of war directed against their own country. The non-combatant inhabitants, however, can be forced to perform any service of non-military character. Non-combatants are prohibited under penalty of death from hostile operation against the occupant, such as giving information to the enemy. Article 50 lays down that no collective penalty, pecuniary or otherwise, might be inflicted on the inhabitants for the acts of individuals, for which they cannot be regarded as collectively responsible. This rule was followed in breach by Germany both in the Great War of 1914–18 and the World War of 1939–45, when that country imposed collective punishment on the inhabitants of that occupied territory in several cases. Article 43 provides that the occupant must respect, unless prevented by laws in force in the country, but he may set up military courts instead of the ordinary courts. The courts, however, pronounce judgment in the name of the legitimate government and not in the name of the occupant power. Requisitions, contributions, and fines. The Hague regulations permit requisitions so far as they are required for the necessities of the army of occupation and are in proportion to the resources of the country. They can be demanded only on the authority of the commander in the locality occupied. They should be made in writing and receipts are to be given for the articles supplied. Contributions are permissible only when the yield is small from taxes and is insufficient to provide for the expenses of the administration. Receipts are to be given to the contributors, although no provisions have been made for the repayment. Article 50 of the Hague Regulations declares that no general penalty, pecuniary or otherwise, can be inflicted on the population on account of the acts of the individuals for which they cannot be regarded as collectively responsible. Geneva Convention, 1949. The ruthless atrocities committed by Germany as a belligerent occupant on the civilian population of the occupied territory during the Second World War necessitated revision of the Hague Regulations and the adoption of the Geneva Convention of 1949. Articles 47 to 78 of the Convention relating to the protection of civilian persons in time of war deal exclusively with occupied territories and are declaratory of existing provisions, though in some respects they go beyond the provisions of the Hague Regulations. Under Article 49, individual or mass forcible transfers, as well as deportations of protected persons from occupied territory to the territory of the occupying power or to that of any other country, are prohibited. The Convention forbids the occupying power to compel the inhabitants of the occupied territory to serve in its armed or auxiliary forces. The occupying power may not alter the status of public officials or judges in the occupied territories. Art. 54. Destruction of real or personal property of individuals, of the state, or other public authorities is prohibited, except where such destruction is rendered absolutely necessary by military operations. Art. 53. The penal laws of the occupied territory shall remain in force, with the exception that they may be repealed or suspended by the occupying power in cases where they constitute a threat to its security. The death penalty may be imposed by the occupying power on a civilian inhabitant only in cases where the person is guilty of espionage, of serious acts of sabotage against the military installations of the occupying power, or of international offenses which have caused the death of one or more persons. Protected persons shall not be arrested, prosecuted, or convicted by the occupying power for acts committed or for opinions expressed before the occupation, with the exception of breaches of the laws and customs of war. Art. 70. Article 55 casts a duty on the occupying power of ensuring the food and medical supplies of the population. Q. 68. Distinguish between military occupation, belligerent occupation, and annexation. Give in brief the facts and the principles laid down in Rev Mons. Sebastião Francisco Xavier dos Remedios Monteiro v. The State of Goa, decided by the Supreme Court of India. Ans. Military occupation, belligerent occupation, and annexation. Military occupation is temporary de facto situation which does not deprive the occupied power of its sovereignty, nor does it take away its statehood. All that happens is that pro tempore the occupied power cannot exercise its rights. In other words, belligerent occupation means that the government cannot function and authority is exercised by the occupying force. Annexation, on the other hand, occurs when the occupying power acquires and makes the occupied territory as its own. Annexation gives a de jure right to administer the territory. Annexation means that there is not only possession but uncontested sovereignty over the territory. As Greenspan put it, military occupation must be distinguished from subjugation, where a territory is not only conquered but annexed by the conqueror. There is, however, a difference between true annexation on the one hand and premature annexation, or as it is sometimes called anticipated annexation on the other. Jurists regard annexation as premature so long as hostilities are continuing and there is an opposing army in the field even if the occupied power is wholly excluded from the territory. Anticipated annexation by unilateral action is not true annexation. True annexation is only so when the territory is conquered and subjugated. In Rev Mons, Sebastião Francisco Xavier dos Remedios Monteiro v. The State of Goa, 26 March 1969, the Supreme Court of India observed that the Geneva Conventions rightly lay down that annexation has no effect on the protection. But they speak of premature or anticipated annexation. Premature or anticipated annexation has no effect. Such a plea was negatived for the same reason by the Nuremberg Tribunal. In fact, when the convention itself was being drafted, the experts were half inclined to add the word alleged before annexation in Art. 47 to distinguish between annexation following conquest and subjugation, and annexation made while hostilities are going on. Subjugation puts an end to the state of war and destroys the source of authority of the existing government. In subjugation, which is recognized as one of the modes of acquiring title, not only the de facto but also the de jure title passes to the conqueror. After subjugation, the inhabitants must obey the laws such as are made and not resist them. Thus the principle which is accepted is that the occupying power must apply the convention even when it claims during conflict to have annexed the occupied territory. However, when the conflict is over and there is hostile army in the field, annexation has the effect of creating a title to the territory. The question, when does title to the new territory begin, is not easy to answer. Some would make title depend upon recognition. Mr. Stimon's doctrine of non-recognition in cases where a state of things has been brought about contrary to the Pact of Paris was intended to deny root of title to conquest. But when Italy conquered Abyssinia, the conquest was recognized because it was thought that the state of affairs had come to stay. Thus, Although the United Nations Charter includes the obligation that force would not be used against the territorial integrity of other states, Art. 2, Para 4. Events after the Second World War have shown that transfer of title to territory by conquest is still recognized. Professor R.Y. Jennings poses the question, what is the legal position where a conqueror having no title by conquest is nevertheless in full possession of the territorial power and not apparently to be ousted? He recommends the recognition of this fact between the two states. If cession after defeat can create title, occupation combined with absence of opposition must lead to the same kind of title. In the present case, Goa, which was a Portuguese colony for about 450 years, was occupied by the Indian Armed Forces on 19 December 1961, following a short military action. The military engagement was only a few hours' duration and then there was no resistance at all. The Geneva Convention ceased to apply after 20 December 1961. The Indian government offered Rev. Father Montero Indian nationality and citizenship, which he refused, and retained his Portuguese nationality. As a Portuguese national, he could only stay in India on taking out a permit. He was, therefore, rightly prosecuted under the laws applicable to him. Q. 69. Write a note on the warfare on the sea. Point out the main laws of maritime warfare. Ans. Laws of maritime warfare. Before the 19th century, laws of maritime warfare were mostly in the form of customs. Since 19th century, several international conferences have been held, and as a result of which at present, besides the customs, the laws of maritime warfare are mainly in the following international treaties or declarations. 1. Declaration of Paris, 1856. 2. Hague Convention, 1907. 3. Geneva Submarine Protocol, 1936. Following are the main laws of maritime warfare. 1. Attack on public and private enemy ship. During naval war, the belligerent states are entitled to attack the enemy ships and destroy their property. The general rule admits the following exceptions. A. Hospital ships. According to Hague Convention, 1907, hospital ship cannot be attacked. B. Vessels employed in religious, scientific, and philanthropic works. According to Hague Convention of 1907, vessels employed for religious, scientific, and philanthropic missions can neither be seized nor attacked. To attack or seize such ships has been declared illegal according to the said convention. C. Cartel ships. Cartel ships or ships carrying prisoners of war cannot be attacked. Attack on such ships has been prohibited by the rules of maritime warfare. D. Fishing smacks and market boats. In accordance with the provisions of the Hague Convention, fishing smacks and market boats engaged in their local profession and which are unarmed cannot be seized or otherwise destroyed during naval war. E. Immunities of merchants. Hague Convention of 1907 provides the following immunities to the merchants. After the beginning of the war, the merchants detained in the ports are given certain facilities. 2. Those merchants and persons who have reached the ports because of their lack of knowledge of war have also been provided certain facilities. 3. Mail boats and mail bags. Maritime rules of international law provide certain immunities in regard to mail bags and mail boats. On the basis of the experience of the First World War, states have entered into treaties in this connection and have agreed to provide certain protections and immunities to mail boats and mail bags. 2. Merchant ships of enemy. Merchant ships of enemy can be destroyed during maritime warfare. 3. The crew of the ship. As pointed out earlier, enemy ships can be destroyed during naval warfare. However, it is provided that while sinking or destroying the ship, proper and necessary articles, papers, etc. on the board of the ship. Such crew and passengers of the ship cannot be attacked unless and until they resist valid right of the belligerent state to visit and search the ship. 4. Merchant ships are entitled to defend themselves against the attack of the enemy. 5. During maritime warfare, merchant ships can be converted into men of war, warships. According to British practice, the conversion of merchant ships into men of war can be made by belligerent state in its own port. It cannot be made in a neutral port. 6. Bombardment of the coastal cities. According to Hague Convention, coastal cities can be bombarded or otherwise attacked during maritime warfare, but bombardment over undefended cities has been prohibited. This could be done only when the local inhabitants resist the supply of food materials and other essential supplies to the enemy. 7. Ordinarily, only the places of military importance can be bombarded. Other places can be bombarded only when they are necessary for the achievement of military objectives. 8. Contact mines. It is laid down in the Hague Convention that the laying of anchorless contact mines is contrary to international law. As regards the laying of floating mines under the sea, it is provided that they should not be laid indiscriminately. It is the duty of the belligerent state laying such mines to give intimation of the area where such mines have been laid to neutral and other states. As rightly pointed out by Stark, unfortunately the law as to mines is uncertain because of the weakness of the text of the Hague Convention 8, submarine contact mines, and because of the development of new types of mines and new kinds of mine-laying methods. Q70. State the law that governs submarine warfare. Ans. Law of submarine warfare. Following are the main rules relating to the laws of submarine warfare. 1. It was laid down in the Treaty of Washington, 1922 that the use of submarine to destroy merchant or commercial ship was against international law and hence it was prohibited. 2. Next important treaty which laid down rules relating to submarine is the London Naval Treaty of 1930 signed by the U.S., UK, France, Italy and Japan. Article 22, Part 4 of the treaty provided that rules of international laws relating to surface vessels would also apply to submarines, particularly in respect of the attack on merchant ships. Thus, a submarine should not sink a merchant vessel without ensuring the safety of the passengers, crew and papers of the ship. As made clear in Article 23 of the treaty shall remain in force for an indefinite period. 3. Yet another landmark is the London Submarine Protocol of 1936, which was signed by the US, UK, France, Italy and Japan in London. It incorporated Part 4 of the Naval Treaty of 1930 mentioned above. Germany and USSR acceded to the protocol in 1936 and 1937 respectively. But as pointed out Professor DPU, Counsel, in the case of submarine warfare, the rules in London of 1936 are viable only in the ideal circumstances, which are unlikely to ever occur in practice. Self-defense is then the only criterion of submarine warfare, and it becomes a matter of technological evaluation to ascertain the factors proportionality and necessity which legitimize submarine warfare in times of limited hostilities. 4. Last but not the least instrument is the new Agreement of September 1937 dealing with the suppression of attacks by submarines against merchant vessels. A remarkable thing about this agreement is that it provided that the provision of the Treaty of 1930 and London Protocol of 1936 were declaratory of international law. As with other rules of war, the above rules were also flagrantly violated during Second World War. Q. 71. What steps have been taken to regulate the use of aerial warfare? Ans. Aerial warfare. The Second World War brought about a complete transformation in the conception of international law in relation to aerial warfare by the use of atom bomb. The rules laid down at various conferences may, however, be summarized as under. The Brussels Conference. In 1874, at the Brussels Conference convened at the instance of the Emperor of Russia, rules on law and usages of air warfare were laid down. The rules laid down that towns, agglomerations of houses, or villages, which were open or undefended, could not be attacked or bombarded. All necessary steps should be taken to spare, as far as possible, buildings devoted to religion, arts, science, and charity, hospitals and places where sick and wounded were collected, on condition that they were not used at the same time for military purposes. The Hague Conference. The First Hague Conference of 1899 attempted to prescribe definite rules with regard to aerial warfare. It laid down that the attack or bombardment of towns, villages, dwellings or buildings which were undefended was prohibited. It forbade the discharge of projectiles and explosives from balloons or by other similar new methods for a period of 5 years. The convention laid down that a neutral power was bound to see that no fight on the air took place. The Institute of International Law at Madrid. The Institute of International Law at Madrid in 1911 adopted the principle that aerial war is allowed provided that it does not present for the person or property of the peaceable population greater dangers than land or sea warfare. First World War. During the First World War, the distinction between combatants and non-combatants almost disappeared, and by the end of the war, bombardment of open towns outside the region of military objectives had almost become a common feature. Washington Conference. As a result of the First World War, it was found that the regulations for the use of aircraft in war were utterly inadequate to meet the exigencies of the situation. Accordingly, in 1922 at the Washington Conference on the Limitation of Armaments, a resolution for the appointment of a commission of jurists to consider the problem of aerial warfare was passed, and the Committee on Aircraft. The Washington Conference enunciated in 1923 various provisions of the proposed Code of Air Warfare Rules. The code was, however, not ratified, but still the various provisions serve as a guide for the use of aircraft in land and naval warfare. The important clauses embodied in the Air Warfare Rules, 1923, may be summarized as under. 1. Arming of private aircraft even in self-defense is absolutely forbidden. 2. Aerial bombardment for the purpose of terrorizing the civilian population, of destroying, damaging private property not of military character, or of injuring non-combatants, is prohibited. 3. Aerial bombardment for the purpose of enforcing compliance with requisitions in kind or payment of contributions in money is prohibited. 4. Aerial bombardment is legitimate only when directed at military objective, the destruction of which would constitute distinct military advantage to the belligerent, e.g. military establishments, munition factories, and lines of communication used for military purposes. 5. Aerial bombardment is not legitimate even when directed at a military objective if it cannot be bombarded without the indiscriminate bombardment of the civilian population. 6. Bombardment of cities, towns or buildings not in the immediate vicinity of the operations of land forces is prohibited. 7. Bombardment in the immediate neighborhood of the operations of land forces is permitted only when there exists a reasonable presumption that the military concentration is sufficiently important to justify such bombardment. 8. Buildings devoted to public worship, art, religion, science, charity, historical monuments, and hospitals for refugees are to be spared. 9. The laws of war and neutrality applicable to land troops are applicable to aerial warfare also. 10. A belligerent state is liable to pay compensation for injuries to persons or to property caused by the violation by any of its officers or forces of the provisions of the above rules. The Geneva Protocol. The Geneva Protocol of 1925 prohibited the use of gas and bacteria in warfare. Disarmament Conference. The General Commission of the Disarmament Conference adopted a resolution in July 1932 which provided that air attack against civilian population shall be absolutely prohibited. Second World War. The Second World War witnessed an utter disregard of the rules of aerial warfare. There was a complete violation of the rules by indiscriminate bombing by German aircraft. The British and American air fleets also in their turn carried on an equally indiscriminate and ruthless bombing of German cities. The whole war was fought without any regard of the rules of warfare, and non-combatants were mercilessly killed and buildings devoted to public worship, art, religion and historical monuments were bombarded. As the climax of it all came the use of the flying bomb by Germany and atomic bomb by America against Hiroshima and Nagasaki on August 6 and 9, 1945, respectively, without giving due warning of danger to non-combatants and in defiance of the protests of many of the scientists who had worked on the project. While the use of flying bombs was spread over a number of months, the atom bombs caused heavier destruction in a very short time. The use of atom bomb in the war was a violation of the rules of international law governing civilized warfare from times immemorial. Its use is a crime against international law and humanity. The Nuclear Test Ban Treaty, 1963, banned nuclear tests in the atmosphere, in outer space, and underwater. This agreement greatly reduced the dangers of radioactive fallout by restricting nuclear tests to underground. The Outer Space Treaty of 1967 prohibited the stationing of nuclear arms in space. Under the Treaty on the Non-Proliferation of Nuclear Weapons, which came into force on 5 March 1970, the signatories pleaded not to assist other countries in any way to acquire nuclear weapons. The ban on emplacement of nuclear weapons on the seabed, banning nuclear weapons on the Moon or in orbit around the Earth, the UN Convention on the Prohibition of Bacteriological and Toxic Arms, 1972, and the U.S.-Soviet Treaty on the Limitations of Anti-Ballistic Missile Systems, 1972, are other achievements in the field of arms limitation. On 3 July 1974, the U.S.A. and the USSR agreed on a partial ban on underground nuclear testing to be effective from 31 March 1976. Q72. What do you understand by the legality of nuclear tests? Give your answer with examples. Ans. The Pokhran explosion. On 18 May 1974, India successfully carried out her maiden underground nuclear explosion at Pokhran in the Thar desert of Rajasthan. While it was hailed by some countries as a significant achievement, others, for example, Canada, Japan, United States, and Pakistan, reacted adversely to it. Indian Prime Minister and other Indian government spokesmen repeatedly assured the world that the explosion was not designed to manufacture nuclear weapons, but to harness the energy for the peaceful purposes. The Pokhran test raised the question whether it violated any rules of international law. Two treaties are relevant to the present discussion, namely, the Nuclear Test Ban Treaty, 1963 and the Treaty of Non-Proliferation of Nuclear Weapons of 1968. The Nuclear Test Ban Treaty under Article I prohibits nuclear explosion in the atmosphere, including outer space, water, and in any other environment if such explosion causes radioactive debris to be present outside the territorial limits of the state under whose jurisdiction or control such explosion is conducted. Thus, under this treaty, underground nuclear test is not prohibited. Moreover, a nuclear explosion which caused radioactive debris to be present at the territorial limits of the state under whose jurisdiction or control such explosion is conducted will also be contrary to this treaty. It is now well established that the Pokhran test was fully contained one. It did not lead to a considerable increase in radioactivity in the atmosphere, and it did not at all affect the neighboring or other sovereign states. A sovereign state is free to do anything within its territory so long as its act does not affect other states. As regards the Treaty on Non-Proliferation of Nuclear Weapons 1968, India is not party to it, and therefore, the question of violation of its provisions does not at all arise. It may be noted that India did not join this treaty because in her view this treaty would perpetuate the already established monopoly of the big powers over nuclear weapons. Besides, being highly discriminatory, the treaty places totally unjustified restrictions on the peaceful uses of atomic energy. Besides this, the Pokhran explosion is also not contrary to general and customary international law. In view of the above discussion, it may be concluded that nuclear test conducted by India at Pokhran is not contrary to the rules of general international law or applicable treaty norms. India was within her legal rights to explode the nuclear device. The criticism by some nations of India was clearly motivated by extralegal and political considerations. Case of shooting down of a Pakistani plane by Indian armed forces during Kargil conflict. Pakistan filed a case in the International Court of Justice against India claiming compensation for shooting down of a Pakistani plane by Indian armed forces. India challenged the jurisdiction of the World Court on the ground that under the Simla Agreement India and Pakistan had agreed to settle their disputes bilaterally and not to refer it to a third party. Accepting India's claim, the World Court held that it had no jurisdiction to decide the case and dismissed the case. It was yet another Pakistani defeat in respect of the Kargil conflict. Q. 73. What do you mean by war crimes? Discuss the various categories of war crimes. Ans. Professor Oppenheim has given a wider definition of war crimes in the following words: war crimes are such hostile or other acts of soldiers or other individuals as may be punished by the enemy on capture of the offenders. The Nuremberg Tribunal classified the crimes punishable under international law into the following three categories. 1. Crimes against peace. 2. War crimes, and 3. Crimes against humanity. 1. Crimes against peace. Article 6 of the Charter of Nuremberg enumerated following crimes against peace: planning, preparation, initiation, or waging of a war of aggression, or a war in violation of international treaties, agreements or assurances, or participation in a common plan or conspiracy for the accomplishment of any of the foregoing. 2. War crimes. An exhaustive definition of war crimes has been given in Principle 4 of the said report. According to it, war crimes are the violation of the laws and customs of war which include but are not limited to murder, ill-treatment or depredation to forced labor or for any other purpose of civilian population or in the occupied territory, murder or ill-treatment of the prisoners of war or persons on the seas, killing of hostages, plunder of public property, wanton depredation of cities, towns or villages or devastation not justified by military necessity. 3. Crimes against humanity. The Nuremberg Charter described crimes against humanity as the crimes such as murder, extermination, enslavement, deportation, and other inhumane acts committed against any civilian population before or during the war of persecutions on political, racial or religious grounds in execution of or in connection with any crime within the jurisdiction of the tribunal, whether or not in violation of the domestic law of the country where perpetrated. While speaking before the Committee of the General Assembly considering the report of the International Law Commission, Indian Ambassador Mr. Jia Gharekha said that India extended her support to the formulation of a comprehensive code of crimes against peace and security of the mankind and that it should be made an effective instrument of international legal significance. Crimes such as genocide, apartheid and slavery should be included in the list of crimes against humanity. As regards war crimes, he said that India favored replacement of the term with violations of rules of armed conflict. Recently, in October 1992, the UN Security Council authorized to investigate the war crimes committed in Bosnia. Though its scope is not very wide, it represents a landmark in the history of the United Nations. It is no doubt not a permanent machinery, but it will certainly establish an important precedent. Q. 74. Present briefly the main arguments, A. For and B. Against the validity of the Nuremberg Trial and evaluate the importance thereof in the future development of international law. Ans. A. Nuremberg Trial. The justification for the Nuremberg Trial was sought on the ground that the League of Nations, including Germany, had declared aggressive war to be a crime on 24 September 1927. Then the Kellogg-Briand Pact or the Pact of Paris, which was signed in 1928 on the initiative of Frank B. Kellogg, at the time U.S. Foreign Secretary, in cooperation with Briand, French Foreign Minister, condemned war as an instrument of settling international disputes and undertook to settle such disputes by peaceful methods. The signatory nations were almost all the nations of the world, including Germany, Japan and Italy. They had bound themselves not to resort to war as an instrument of national policy. Unprecedented atrocities aroused a united determination in all the Allied countries to exact retribution and the victory of the Allied armies by occupation of Germany enabled them to take immediate steps for the constitution of a military tribunal to avoid the fiasco of the Versailles war trial provisions. B. Criticism of the trial. Great reliance was placed on the Pact of Paris, or the Calabrian Pact of 1928. Such implicit reliance could not be placed on it for the launching of the prosecution of the vanquished leaders and generals. In the first place, neither the Pact of Paris nor the Hague Conventions of 1899 prescribed any sanctions for the enforcement of the provisions contained in them. The words of the pact were not those of a penal statute. They were the language of theology, not of law. In the second place, although the Calabrian Pact declared aggressive wars as illegal, such illegality could by no stretch be transformed into international crime so as to make each individual participant liable for the same. In the last place, the Pact of Paris ever since its inception was followed in breach. Schick in his book The Nuremberg Trial entertains grave doubts about the correctness of the assertion of the Allies that the Charter of the International Military Tribunal was based on a historical legal precedent. It has also been suggested that the Court of Victors was not a proper tribunal which should have been represented by neutral and German judges as well. It could by no stretch be termed an international court. Professor Smith contends that the trial violated the fundamental principle of impartiality, the ideal symbolized by the traditional figure of justice blindfolded and holding a balanced scale. Although the tribunal refuted the contention raised by the defendants that there can be no punishment of crime without a pre-existing law and that ex post facto punishment is abhorrent to the law of all civilized nations, eminent jurists have doubted the correctness of the principles of law laid down by the tribunal on this point. Schick observes that the Charter applied with retrospective effect, which was a rule contrary to municipal law of civilized nations and was, therefore, in violation of international law. Professor Smith further observes that until 1942 the British Manual of Military Law contained an article, ch. 14, art. 443, to the effect that superior orders constituted a good defense to charges of war crimes. In April 1942, the War Office by an amendment destroyed the defense of superior orders. This, observes Professor Smith, was an extreme example of legislation ex post facto. The main objection against the trial was that the prosecution of members and servants of a government for leading their country into aggressive war amounted to retroactive criminal legislation and violated the salutary principle of criminal law that no punishment was to be imposed for an act not defined as a crime with stated penalties by law in force at the time of commission. Importance of the trial in international law. The Nuremberg Trial has set up a new precedent in the history of international law and constitutes a milestone in its progress. The trial clearly establishes that the plea of obeying orders of a superior or of his government does not relieve him from responsibility under international law provided a moral choice was, in fact, possible to him. This trial has enhanced the sanctity of solemn agreements and undertakings like the Kellogg Pact. International law is now no more regarded a branch of ethics. It received new vigor and strength on account of the principles laid down at the trial. The trial emphasized that international law cannot work in vacuum, and for its proper functioning with greater momentum it has to depend upon the spirit of cooperation of the individuals who are to be regarded as the pillars for the preservation of international law by showing that it is no respecter of persons. Any person committing a crime under international law, whether highly placed or not, shall be adjudged guilty and punished on a fair trial on the facts and law. The trial has enunciated in unambiguous terms the principles of international law regarding preparation of war, occupation of enemy territory, execution of hostages, and treatment of prisoners. Q. 75. A German officer instructed an escort of British airmen not to interfere with civilians who might molest the prisoners. When the prisoners were marched through Essen, a crowd collected and killed the prisoners. The officer who gave the instructions, the sergeant in charge of the escort, and 3 civilians who are alleged to have actively participated in the killing are accused of having committed war crimes. Discuss. Ans. Ill-treatment and killing of prisoners of war amounts to war crime because these are in violation of the recognized rules of warfare. So the German officer, the sergeant in charge of the escort, and the 3 civilians who participated in the killing of the prisoners of war have committed war crime according to the established rules of international law and custom. Q. 76. Define. A. The scuttled and boats case. B. Tokyo trial. Ans. A. The scuttled U-boats case, 1940. 1 Law Reports of Trials of Criminals 55. This case relates to war crimes and the punishment of war criminals. The Northwestern Command of the German Armed Forces surrendered on 4 May 1945 before the Allied nations. The surrender included all the sea vessels in the said area. The surrender was made in consequence of an armistice agreement. After the signing of the instrument of surrender but before it came into effect, the German officers ordered their subordinate officers to scuttle the U-boats. Later on this order was countermanded. But the accused, who was an instructor of the U-boats, ordered the scuttling of U-boats, and consequently the U-boats were scuttled. The accused was arrested and was prosecuted for violating the laws of war. In his defense, the accused put forward the following 2 arguments. I. The terms of the instrument of surrender were not known to him as they were not intimated to him. 2. He did not know or receive the information of countermanding of the original order regarding cutting of U-boats. The accused was held guilty and was sentenced to 5 years imprisonment. The court held that by May, it had become clear that the U-boats had become the property of the Allied nations and could not therefore be destroyed. The court propounded the following principles. I. If the armed forces of a state surrender after an armistice agreement, then the agreement shall be binding on both the states, i.e., the surrendering state, and the state to whom the surrender is made. If after the surrender, the soldiers do not observe and follow this agreement, they will be guilty of the violation of the law of war. 2. If a person scuttles the boats or otherwise causes harm to them after the armistice agreement and surrenders in pursuance thereof, he will be guilty of war crimes because after the surrender war boats become the property of the conquering state. Ans. B. Tokyo Trial. As Nuremberg Tribunal was established to try war criminals of Germany, the Tokyo Tribunal was established to try the war criminals of Japan. The Tokyo Tribunal was established by the victorious states by making an agreement and subsequently by issuing a charter conferring jurisdiction upon the court. The Tokyo trial started hearing on 4th June 1946 and was presided by Sir William. A special feature of this trial was that its judges were not only from the victorious states, but some of the judges belonged to other states also. For example, the eminent Indian jurist Dr. Radha Vinod Pal was one of the judges of the Tokyo Tribunal. Besides this, there were some judges from Philippines and other countries of the Commonwealth of the Nations. During the trial, the accused objected that they could not get justice from this trial because most of the judges belonged to the nations which defeated Japan, but this objection was rejected by the court. The Tokyo Tribunal awarded death sentence to those persons who were guilty of conducting and organizing war and awarded imprisonment for different terms to other persons accused of war crimes. Q. 77. Define. A. Peleus trial. B. H-man case. C. Malay trial. Ans. A. Peleus trial. Peleus was a Greek ship which was sunk by the German U-boat. After sinking the ship, the commanders of the U-boat ordered firing upon the members of the crew of the ship who were trying to save their lives through lifeboats. Thus, out of 35 people, 22 members of the crew lost their lives in consequence of firing. After some weeks, when on account of air attacks, the U-boats were compelled to come to the coast, officers on board of the boats were arrested and were prosecuted for war crimes. The court ruled that it is the fundamental usage of war that firing on unarmed enemies is prohibited. The court referred to an old case, namely Landovery Castle, 1921, wherein it was laid down, took war of land, the killing of an unarmed enemies is not allowed. Similarly, in war at sea, the killing of shipwrecked people who have taken refuge in lifeboats is forbidden. During the trial, the accused contended that they were not guilty because they fired on the orders of the superior officers, but the court rejected the plea of superior orders and held that they were bound to obey only lawful orders of their officers. There is no duty to observe orders which are not lawful. Consequently, the accused were held guilty and were duly punished. B. H-man case, 1962. Under Hitler, Eichmann had committed many Nazi atrocities upon the Jews. The charge against him was that he was responsible for the murders of lakhs of Jews and for inhuman treatment towards them. The spies of Israel were after him for a long time, but he was fleeing from one country to another and escaping arrest and trial. Ultimately, the Israeli spies caught him in Argentina. But on account of the fear that the government of Argentina might not extradite him for prosecuting him for having committed war crimes, the Israeli spies took him from Argentina to Israel in an irregular way. In Israel, Eichmann prosecuted for war crimes and was sentenced to death. An appeal was filed in the court of Israel. It was contended on behalf of Eichmann that the courts of Israel did not possess the jurisdiction to try him because when the crime were committed by him, Israel as a state did not exist. That is to say, crime was committed during the Second World War and Israel came into existence after that. But the Supreme Court of Israel rejected this argument and propounded the principle of universal jurisdiction in respect of war crimes and genocide. C. My Lai Trial. My Lai is a village in Vietnam, the whole of population which was killed by American military personnel. It was clearly a war crime. Consequently, there was a great reaction in the international community. America was charged of having encouraged perpetration of war crimes of military officers in Vietnam. American nationals also expressed their resentment against atrocities and war crimes. Due to the reaction of the international community as a whole, and the pressure of the American nationals at home, the government of America was compelled to hold a trial of the officer responsible, Lieutenant Cale. The court held the accused guilty and awarded punishment to him. My Lai trial is a landmark event in respect of the punishment awarded to war criminals for the violation of the war crimes. Hitherto war trials were such wherein the victorious state had conducted the war crimes trials against the criminals of the vanquished nations, but My Lai trials mark the beginning of a new trend which shows that there will be circumstances wherein because of the reaction or public opinion of the international community and the pressure of its own nationals, a state may be compelled to hold war criminals' trials against its own officers. It is undoubtedly an auspicious beginning and augurs well for the observance of laws of war in future. Q. 78. Define genocide with at least one example. Ans. Meaning and definition of genocide. Article 2 of the Genocide Convention defines the term genocide. According to it, genocide means any of the following acts committed with intent to destroy in whole or in part a national, ethnical, racial or religious group as such. A. Killing the member of the group. B. Causing bodily or mental harm of the group. C. Deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. D. Imposing measures intended to prevent births within the groups. E. Forcibly transferring children of one group to another group. Genocide, a crime under international law. The term genocide was coined by Lemkin, a private individual whose efforts played a large part in promoting the United Nations work on genocide. Article I of the Genocide Convention, 1948, therefore, provides that the contracting parties confirm that genocide, whether committed in time of peace or in time of war, is a crime under international law which they undertake to prevent and punish. Under Article 3 of the Convention, following acts are punishable: b. Conspiracy to commit genocide, c. Direct and public incitement to commit genocide, d. Attempt to commit genocide, and e. Complicity in genocide. Article B of the Genocide Convention. Example of genocide in Bangladesh. The military regime of Pakistan under General Tikka Khan committed genocide which is unprecedented in the annals of world. As pointed out by M.K. Nawaz, the Bengali people have a language and culture different from the people of West Pakistan, can accordingly be considered as ethnical group within the meaning of Article 2 of Genocide Convention. Justice V.R. Krishna Iyer, the then member of the India Law Commission, has also pointed out the Bengali population of East Pakistan probably falls under the national and ethnical group, not merely territorial or linguistic. Thus, the genocide committed by Pakistani military personnel in Bangladesh was clearly and without a shade of doubt an international crime. Justice V.R. Krishna Iyer has remarked, the scenes of blood and bestiality ensuing from the military crackdown under General Tikka Khan's deadly direction was such the like of which no eye had seen and no tongue would adequately tell. Bangladesh is fortunately free today, but its sweetest songs of freedom are those that tell of saddest thought of the million dead. The appalling human annihilation perpetrated by military personnel of Pakistan in Bangladesh, its dimensions and dastardliness prima facie constitutes an international crime. Q. 79. What are the different modes of termination of war? Ans. Modes of termination of war. Generally, the following are the modes of termination of war. 1. Simply cessation of hostilities. Sometimes, during the war, the belligerent states cease hostilities without any definite understanding being reached between them. The examples of such types of cessation of war are between France and Spain, 1770, war between Russia and Prussia, 1801, war between Spain and Chile, 1878, etc. Termination of war through this mode is not in accordance with the present circumstances because in this mode of termination of war, no agreement or understanding is reached and it does not determine as to what will be the fate of prisoners of war, how shall boundaries be fixed or determined, and what shall be the fate of the property under the occupation of the belligerent state or other type of property. Consequently, this mode of termination of war presents many difficulties. 2. Conquest followed by annexation. Sometimes it so happens that a belligerent state conquers another state and annexes it into its territory. According to international law, the annexed territory or state ceases to have any independent importance under international law. This mode of termination of war may present difficulties when the belligerent state concerned has annexed the territory in violation of the rules of international law. There is no clear rule of international law in this connection. However, it is definite that the war comes to an end after one belligerent state conquers the other belligerent state and annexes the territory of that state into its own territory. 3. By a peace treaty. War may also be terminated by the conclusion of a peace treaty. The advantage of this mode of termination of war is that some understanding is reached in regard to that treatment of prisoners of war, property and other relevant matters connected with war. The principle of postliminum also comes into force when war comes to an end through this mode. According to this principle, in the absence of any agreement to the contrary, the persons and things come to their original position after their release from the occupation of the enemy. 4. By armistice agreement. Sometimes wars are terminated by the conclusion of armistice agreement. Under this mode of termination of war, the hostilities cease for temporary period, but since the state of war continues between the states, the war may erupt at any time. 5. By unilateral declaration of one or more of the victorious powers. Sometimes war may come to an end by the unilateral declaration of one or more of the victorious powers. For example, Indo-Pak War of 1971 came to an end in consequence of the unilateral declaration by India to end the war. The war came to end because Pakistan also respected this declaration and ceased hostilities. It is not essential that the date of the termination of war should also be the date of conclusion of peace treaty, or the date when the hostilities actually ceased. It is a matter to be determined by state law. There is no rule of international law which binds states to treat the conclusion of war as the date of the conclusion of peace treaty. Q80. Explain doctrine of postliminum with the case law. Also describe the limitations of the doctrine. Ans. Doctrine of postliminum. The doctrine of postliminum was incorporated into international law from Roman law. According to it, persons and things released from the occupation of the enemy come to their original position, or they are restored to their original position after the end of war. According to Roman law, this was applied on persons and things. According to international law, this is applied in the context of war. If any state remains under the occupation another state for a temporary period and then consequently becomes independent after its independence, persons and things come to their original position in accordance with the principles of postliminum. This principle cannot, however, be applied in matters of neutral states. Private movable property can be seized by the occupying power, and therefore, the principle of postliminum does not apply on such properties. However, public property can be seized by the belligerent states only when and insofar as is essential for the objectives of war. If after withdrawal of the enemy the property remains, then it comes or is restored to its original position. The principle of postliminum also applies on immovable property. In fact, the principle of post-eliminum applies only when the occupying power has exceeded its powers or has acted beyond its rights. Thus the legal and valid acts performed by the occupying power are beyond the scope of the principle of post-eliminum. Limitation of the doctrine of post-eliminum. Following are the limitations of the doctrine of post-eliminum. 1. It does not apply upon the valid and lawful acts performed by the occupying power. They remain valid even when such occupation ends. 2. This principle also does not apply in case of the realization of taxes made by the occupying powers. 3. The principle of post-eliminum does not apply in respect of the neutral states. 4. It does not apply when one state incorporates another state into its state conquest because conquest followed by annexation changes the status of things and persons. 5. Another limitation of the doctrine of post-eliminum is that it does not apply when an enemy state has finally incorporated the territory concerned as of its territory. Case of Elector of Hesse-Kassel. This case is related to the principle post-eliminum. Hesse-Kassel was a neutral state which was conquered and annexed by France in 1806. Consequently, Elector of Hesse-Kassel fled away from its territory. In 1898, in accordance with the treaty, Elector regained his lost territory. After the death of former Elector, his son claimed to realize past debts on the basis of the principle of post-eliminum. But he could not succeed. In this case, it was held that after the conquest, the conquering states is fully entitled to realize taxes, etc. Napoleon was therefore within his rights to realize debts, etc. Since it was a valid act performed by the occupying power, and it was within the right of Napoleon, the principle of post-eliminum could not be applied in this case. Q81. What do you mean by neutrality? Mention the essential elements. Discuss the development of law of neutrality. Ans. Meaning and definition of the term neutrality. As pointed out by Oppenheim, neutrality is the attitude of impartiality adopted by third states towards the belligerent and recognized by belligerent, such attitude creating rights and duties between the impartial states and belligerents. On the basis of the above definitions, we may conclude that there are following three essential elements of neutrality. 1. Attitude of impartiality. Neutral state is a state which does not take part in war and remains impartial. This impartiality is one of the essential elements of neutrality. 2. Recognition of impartiality by belligerent states. It is also necessary that this impartiality should be recognized by the belligerent states. 3. Creation of rights and duties. The recognition of attitude of impartiality of the neutral state gives rise or creates certain rights and duties. It gives certain rights to neutral states and also imposes certain duties upon it. Similarly, the neutral state also acquires certain rights because of the attitude of impartiality and adopted during the war between the two belligerent states. These rights and duties are recognized under international law and should be observed by the belligerent states as well as the neutral states. Development of the law of neutrality. The term neutrality has been derived from the Latin word neuter, which means impartiality. In wider sense, by neutrality we mean an attitude of impartiality adopted by the states who do not take part in the war. So far as the modern international law is concerned, the law of neutrality started in the Middle Ages. In fact, the word neutrality began to be used since 17th century. But its systematic development could not be achieved until 18th century. In 18th century, the two famous jurists Binker Schock and Vattel contributed much to the development of the law of neutrality. In 18th century it was agreed that the states which do not take part in war are entitled to remain impartial, and this impartiality may confer upon them certain rights. The development of the law of neutrality received a great impetus in the United States of America in 19th century. Much of the credit for this goes to the United States because in the Napoleonic Wars of Europe, America remained a neutral country. The systematic development of the law of neutrality also owes much to the Civil War of America. A leading case of this period relating to neutrality is Alabama Claims Arbitration 1872. In the Civil War of America, Britain was neutral. But Britain provided the facilities to the southern states for the fitting and construction, etc. of Alabama and others destroys in its territory. America claimed that it was a clear violation of the neutrality adopted by Britain. America contended that it was the duty of Britain to prevent such types of acts in its territory. America, therefore, claimed compensation for the violation of law of neutrality by Britain. Britain and America agreed to entrust this matter to the Court of Arbitration. The Court of Arbitration gave its award in favor of America and ruled that Britain should pay $1.55 crore in gold to America. The permanent neutralization of Belgium and Switzerland in 19th century was also a landmark event so far as the development of the law of neutrality was concerned. This encouraged the development of the law of neutrality. The establishment of the League of Nations and then the United Nations greatly affected the law of neutrality in the 20th century. Q82. What do you know about the position of neutrality under the UN Charter? Discuss. Ans. Position of neutrality under the United Nations Charter. Some jurists are of the view that the United Nations Charter has put an end to the old law of neutrality. Professor Kelson has remarked that the rule of impartiality by neutral states is superseded by the Charter. Some other jurists have supported this view. In the view of these jurists, when a state resorts to war there could be only two conditions. It could either be an aggressor or a defender. If it is an aggressor, then preventive or enforcement action can be taken against it under the Charter. If it is a defender, then it should be assisted by the United Nations. Thus, the member states of the United Nations cannot remain neutral. Before we criticize the view of these jurists, it will be desirable and necessary to refer to the relevant provisions in the United Nations Charter which have affected the old law of neutrality. Such provisions are as follows. 1. Article 2(5). Article 2(5) provides that all members shall give the United Nations every assistance in any action it takes in accordance with the present charter, and shall refrain from giving assistance to any state against which the United Nations is taking preventive or enforcement action. 2. Article 25. Article 25 provides that the members of the United Nations agree to accept and carry out the decisions of the Security Council in accordance with the present charter. That is to say, if the Security Council decides to take any the sick, member states have no option but to carry out this decision. Under such circumstances, they cannot remain neutral. 3. Articles 41, 42 and 43. Articles 41, 42 and 43 are relating to the right of enforcement action conferred upon the Security Council in respect of maintenance of peace and security. Under these articles, the Security Council has been empowered to ask other states to assist it. These provisions are in fact detrimental for the observance of the rules of the old law of neutrality. 4. Article 49. Article 49 provides that the members of the United Nations shall join in affording mutual assistance in carrying out the measures decided upon by the Security Council. It has also affected the old law of neutrality. 5. Article 51. Article 51 of the Charter confers upon all the member states of the United Nations the right of individual or collective self-defense if any armed attack occurs against a member of the United Nations. It is clear from the above provisions that the United Nations Charter has greatly affected the old law of neutrality. It is on the basis of these provisions that many jurists have expressed the view that the Charter of the United Nations has put all end to the old law of neutrality. But as against the above view, some jurists have expressed the view that although the provisions of the Charter have greatly affected the old law of neutrality, they have not completely abolished it. That is to say, neutrality can still be practiced under certain circumstances. Thus, the old law of neutrality has not been completely abolished and can be practiced by the member states of the United Nations in certain special circumstances, although in principle the member states of the United Nations cannot claim to remain neutral. Q83. What are the rights and duties of neutral states and belligerent states? Ans. Rights and duties of neutral states and belligerent states. Ordinarily following are the duties of the neutral states. 1. Abstention. It is duty of the neutral state to abstain from rendering direct or indirect help to the belligerent states. For example, the neutral states cannot assist either belligerent through forces or cannot guarantee the loans to be given to them. 2. Prevention. It is also the duty of the neutral states to prevent certain things within their territory. For example, it is their duty to ensure that persons are not recruited for the war forces of belligerent states within their territory. They should also prevent the preparation of war in favor of either of the belligerent states. 3. Acquiescence. It is also the duty of neutral states to give their acquiescence in respect of certain matters. For example, they should give their acquiescence when a ship using the flag of their state is seized for carrying contraband. If they oppose such seizure, it will be deemed to be the violation of the law of neutrality on their part. In addition to the above-mentioned duties, the neutral states have certain other duties, although the following duties are in consequence or connected with the above-mentioned three duties. Such duties are as follows. 1. Restoration. It is the duty of the neutral states not to allow any act connected with the war within their territory, and in case any such act takes, it is their duty to restore it. That is to say, if either of the belligerents seizes enemy ship within the territory of the neutral state, then it becomes the duty of the neutral state to get such ship restored to the other belligerent state. 2. Repatriation. If a neutral state contravenes the above-mentioned duties, it may be held liable to pay compensation for the same. A leading case on the point is Alabama Claims Arbitration, 1872. In this case, Britain had to pay America $1.55 crore in gold in the form of compensation for the violation of the laws of neutrality. Rights and duties of the neutral states have been mentioned in Hague Convention of 1907. Duties of the belligerent states. Following are the duties of the belligerent states. 1. Abstention. It is the duty of the belligerents to abstain from committing act of war within the territory of the neutral states. 2. Prevention. It is their duty to prevent bad treatment towards the ambassadors, citizens, etc. of the neutral states. 3. Acquiescence. Like the neutral states, belligerent states are under duty to give their acquiescence in respect of certain matters. For example, if a state gives asylum or refuge to some members of its forces, or allows temporary asylum or refuge to the enemy within its port, or allows the enemy state to get its ships repaired in its port, then it is the duty of the other belligerent state not to oppose it and to give its acquiescence in this respect. Rights of the neutral states. According to Lawrence, following are the rights of neutral states. 1. The first right of neutral states is that no warlike act should be committed in their territory. 2. Secondly, their cable lines and seas, etc. should not be damaged as far as possible. 3. The belligerent states should not use their territory for making preparation of war. 4. They are also entitled to get certain rules formulated for the protection of their territory and to make the belligerent states observe them. 5. Neutral states also possess right that if their neutrality is violated, then they get compensation for the same. It may, however, be noted that there is a lack of definite principles in this respect, but at least this is definite that they should get adequate compensation for the violation of the law of neutrality, and compensation should be proportionate to the loss or damage suffered by them. Q84. What are the different kinds of neutrality and distinction between them? Ans. Kinds of neutrality and distinction between them. Neutrality may be of following kinds. 1. Perpetual or permanent neutrality. When a state is neutralized through a special international treaty, then such a neutrality is called perpetual or permanent neutrality. 2. General and partial neutrality. When only a part of the state is neutralized, it is called partial neutrality. On the other hand, when the whole state adopts the attitude and policy of neutrality, it is called general neutrality. 3. Voluntary neutrality and neutrality based on some treaty. A voluntary neutrality is a neutrality which is declared by a state voluntarily without being bound by a treaty. On the other hand, a state may become neutral being bound by any general or special treaty. 4. Armed neutrality. When a state uses armed force for the defense or neutrality, it is called armed neutrality. 5. Benevolent neutrality. When a state, while remaining neutral, favors belligerent state or otherwise helps it, is called benevolent neutrality. 6. Perfect and qualified neutrality. When a state remains completely impartial and does not, directly or indirectly, assist either of belligerents, then it is called perfect neutrality. But if a state remains neutral generally but as a result of some provisions of treaties entered into before start of war, directly or indirectly assists any belligerent state, then it is called qualified neutrality. Q85. Differentiate. A. And neutralization. B. Neutrality and neutralism. Ans. A. Distinction between neutrality and neutralization. Neutralization is the permanent status of neutrality of a state. Often it is guaranteed by the international agreement or treaty. Such a state cannot participate in war without violating its neutrality. Professor Schwarzenberger has clarified the distinction between neutrality and neutralization in the following words: whereas under international customary law a neutral power remains free to exchange its status of neutrality for that of war, neutralized state which is a party to a treaty prescribing its permanent neutrality may not do so. It cannot resort to war without a breach of its treaty obligation or release from these by the other parties to the treaty. Switzerland represents this type of state. Switzerland is an ideal neutralized state to the extent that in order to adhere to its neutrality it has not even joined the membership of the United Nations. Austria is also a neutralized state, and its neutrality has also been guaranteed under an international treaty. But Austria has become the member of the United Nations. In the words of Stark, following is the distinction between neutralization and neutrality. Neutralization differs fundamentally from neutrality. which is a voluntary policy assumed temporarily in regard to a state of war affecting other powers, and terminable at any time by the state declaring its neutrality. Neutralization, on the other hand, is a permanent status conferred by agreement with the interested powers, without whose consent it cannot be relinquished. B. Distinction between neutrality and neutralism. According to Schwarzenberger, neutralism is a political and ideal concept, the meaning of which may change in different contexts and circumstances. There is a great difference between neutrality and neutralism. Neutrality is an attitude of impartiality as well as legal status. As compared to it, neutralism is only used to denote the political attitude of a state. As pointed out by Dr. Peter Lyon, neutrality is meant non-involvement in war, while by neutralism is meant non-involvement in Cold War. Professor Schwarzenberger has also remarked, in contrast to neutrality, which presupposes state of war between at least other states, neutralism understood as policy of non-alliance or non-involvement is available as a pattern of policy in times of both peace and war. Q. 86. What is meant by angry? State the leading features by reference to some decided cases. Ans. Right of angry. The right of angry denotes the right of a belligerent state in times of war or other public danger to use or even, when necessary, to destroy such neutral property as happens to be within its territorial jurisdiction at a particular time. It affords a belligerent state to requisition or appropriate, in times of public urgency, vessels, rolling stock, aircraft and other means of transport belonging to the nationals of neutral powers, but lying at the time within its own territorial jurisdiction. This is founded on the principle that the supreme interest of the state overrides the law. It is as well based on the general principle the neutral property in belligerent territory is exposed to like risks as the property of belligerent nationals and is subject to similar liability to requisitions and contributions in time of war and other national emergency. Oppenheim observes that in contradistinction to the original right of angry, the modern right of angry is the right of belligerents to destroy or use in case of necessity for the purpose of offense and defense neutral property on their territory, or on enemy territory, or on the open sea. According to him, this right is a right deriving from the law of war and must not be confused with the right, which every state undoubtedly possesses, of seizing in case of emergency, and subject to compensation, any foreign property on its territory. One ought not, therefore, to speak of a right of angry belonging to neutrals as well as to belligerents, or of a right of angry in peace as well as war. Limitations. The right of angry is a sovereign right and can be exercised by any sovereign state in case of national emergency, provided the goods and means of transport requisitioned are lying within the territorial jurisdiction of the state requisitioning them. 2. The right is confined to the territorial waters of the requisitioning state and does not extend beyond its territorial limits. 3. 3. The right can as well be exercised by a neutral in grave national emergency. Such requisition can only be made subject to the payment of full compensation. 4. The right cannot be exercised by a belligerent in occupation of an enemy territory. The right of angry does not extend to the services of the foreign crew of the ships or aircraft. 6. The application of this right could not be extended to neutral property only passing within a belligerent state. 7. The right would not be used to justify destruction of property as distinguished from appropriation. The Zamora. In the case of Zamora, it was observed by Lord Parker that a belligerent has in a proper case the power to requisition ships and goods of neutrals in the custody of the prize court for adjudication. The legal right or dominion is, no doubt, still in the neutral. The right of requisition is not an absolute right, but a right exercisable in certain circumstances and for certain purposes only. It was, therefore, held that requisition of a vessel or cargo of copper awaiting the judgment of the prize court was allowed provided that a. The vessel or the goods in question must be urgently required for use in connection with the defense of the realm, the prosecution of the war, or other matters involving national security. B. There must be a real question to be tried. And C. The prize court determines judicially whether, under the particular circumstances of the case, the right is exercisable. Q87. The principle of contraband is that you are entitled to stop and capture any cargoes which are going to help your enemy in carrying on the war. Discuss the above statement and classify contraband goods. Ans. Contraband of war. Contraband of war is the designation of such goods as are forbidden by either belligerent to be carried to the enemy on the ground that they enable him to carry on the war with greater vigor. Oppenheim. According to Kelson, contraband of war are goods the transport of which to the enemy is forbidden by either belligerent in conformity with general international law. Contraband of war denotes such articles as are considered objectionable to be carried by a neutral to a belligerent because they are calculated to be of direct service in carrying on war or otherwise assist one of the belligerents in time of war. The same view is expressed in the given statement that the principle of contraband is that you are entitled to stop and capture any cargoes which are going to help your enemy in carrying on the war. Essentials of guilt. Lawrence sums up the essentials of guilt in the matter of contraband in the following words. In the first place, it is transport and not bargain and sale which the law of contraband aims at. Secondly, a belligerent destination is essential. And, thirdly, the offense is complete the moment a neutral vessel laden with contraband leaves neutral waters for belligerent destination. The Imina. Division of commodities. Grotius divided commodities into three classes. 1. Things useful for war only, example, arms, projectiles, powder, etc. 2. Things useless for warlike purposes, example, fashion and fancy goods, clocks and watches, soap, etc. And 3. Things useful in war and peace indifferently, i.e., money, provisions, ships, naval stores, etc. According to him, the first was liable to capture while on their way to an enemy destination, the second was always immune from capture, and the third depended upon circumstances in each case. There is a divergence of opinion as to what articles are to be termed as contraband. The British view favored a long list of contraband goods and divided articles into absolute contraband and conditional, occasional, or relative contraband. Absolute contraband included articles such as arms, machinery for manufacturing them, ammunitions, powder, clothing of military character, etc., while conditional, occasional or relative contraband consisted of articles such as provisions, coal, gold, etc., which were contraband or not according to circumstances. The French view, which was followed by other continental powers, deemed comparatively few articles to be contraband and held that there could not be conditional contraband articles. The same thing was either contraband or not and could not be both, i.e., contraband in one set of circumstances and innocent in another. The Unratified Declaration of London, 1909, made an attempt to settle the long drawn-out controversy between the two conflicting views. It divided articles into three categories, viz. Absolute contraband, conditional contraband, and non-contraband. The subject of contraband engaged the attention of the Supreme Court of America in the case of the Peterhof, where it was observed that a strictly accurate and satisfactory classification is perhaps impracticable, but that which is best supported by American and English decision may be said to divide all merchandise into three classes. 1. Articles manufactured and primarily or ordinarily used for military purposes in time of war. 2. Articles which may be and are used for purposes of war or peace according to the circumstances. And 3. Articles exclusively used for peaceful purposes. Merchandise of the first class, destined to a belligerent country or place occupied by the army or navy of a belligerent, is always contraband. Merchandise of the second class is contraband only when actually destined to the military or naval use of a belligerent, while merchandise of the third class is not contraband at all, though liable to seizure and condemnation for violation of blockade or siege. Article 30 of the Unratified Declaration or London lays down that absolute contraband is liable to capture if destined to territory belonging to or occupied by the enemy or to the armed forces of the enemy. There is a presumption of enemy destination when the ship's papers reveal that the goods are to be discharged in an enemy's port or delivered to his armies or warships. Article 33 provides that conditional contraband is only liable to capture if destined either for the armed forces for a government department of the enemy state. There is a presumption of enemy destination if the conditional contraband is consigned to a fortified place held by the enemy, to one of his bases of operations, to enemy authorities or to a contractor in the enemy country who supplies the enemy government with articles of the kind in question. During the two wars, the Declaration of London underwent a great change, as it was found impossible to adhere to any settled list of classified contraband goods in time of peace. The Orders in Council extended the various provisions of the Declaration of London so as to cover goods consigned to order, or where the ship's papers did not state the consignee, or where the consignee was shown in territory belonging to, or occupied, by the enemy. Q88. From the lawyer's point of view, the effect of what has been done the two world wars has been to merge the law of contraband in the law of blockade. H.A. Smith. Explain the above. Ans. Merger of law of contraband in the law of blockade. The two essential elements of the conception of contraband are the character of goods and an enemy destination. Only such goods as are on the contraband lists and intended to be imported into the enemy territory are liable to seizure and condemnation. Blockade involves the interception by sea of the approaches to the coasts or ports of an enemy with the purpose of cutting all his overseas communications. Its object is not only to stop the importation of supplies but to prevent exports as well. Higgins and Colombo's International Law of the Sea, 2nd ed., p. 538. The essential difference between contraband and blockade is that, unlike the case of contraband, in the case of blockade of any portion of the enemy's coast or any of his ports, all merchant ships of whatever description and of whatever nationality are subject to confiscation, no matter whether they have contraband, conditional contraband, or non-contraband articles. The fact that the ship is attempting to enter or leave a blockaded port or coast is enough for its condemnation. The result is that the main difference between the law of blockade and the law of contraband has been that the former is limited in area and the latter in scope. The old distinction between the law of blockade and the law of contraband seems to have disappeared with two great wars. Owing to the present-day character of the total war where everything is made subordinate to the overmastering dictates of war, the law of contraband has been adopted to perform the functions of blockade, and without the narrow geographical limitations to which the old blockades were restricted. What has been done on both sides during the two great wars amounts to nothing less than an assertion of the right to destroy the whole of the seaborne trade which serves the need of the enemy, under whatever flag it may be carried and through whatever countries it may pass. The methods used by the opposing belligerents differed widely, and the policy adopted by the Allies was technically justified as a reprisal for the illegalities committed by the enemy, but the purpose on each side was the same. H.A. Smith. Q89. A. What do you understand by the doctrine of continuous voyage? Illustrate your answer with examples and refer to leading cases. B. A Turkish vessel, loaded with cloth for the distinct purpose of making coats for the German army, leaves the Turkish harbor for a neutral harbor where the coats are to be prepared, and therefrom transshipped to Germany. Can the goods be seized and the vessel condemned? Ans. A. Doctrine of continuous voyage. The doctrine of continuous voyage consists in treating an adventure, which involves the carriage of goods in ulterior and hostile in the first instance to a neutral port and thence to some ulterior and hostile destination, as being for certain purposes only one transportation, with all the consequences which would attach if the neutral port had not interposed. Pit Cobbett. The neutral vessels sought to evade capture of contraband goods by breaking their voyage into two parts. When they carried contraband of war to an enemy country, they would start ostensibly for some neutral port according to their papers, would land their cargo at the ostensible destination, viz., the neutral port, pay duties, if necessary, reload it, and then try to reach their real destination, viz., the belligerent port. Similarly, for breaking the blockade, they would take as their ostensible destination some neutral port adjoining the blockaded coast and would try to reship the goods to the blockaded port from that neutral port. The application of the doctrine of continuous voyage or continuous transportation, however, foiled the attempt of neutrals to evade the rule with regard to contraband of war or blockade. The doctrine laid down that goods which would be carried to an enemy port could be intercepted as contraband even though they were being carried ostensibly to a neutral port if they are really intended to be forwarded either by land or by sea from the neutral port to hostile destination. The doctrine was first applied by British courts to prohibited trade, when vessels attempted to evade the operation of the rule of the War of 1765 by touching at a neutral port as their apparent destination. It was intended to breach of blockade, the springbok, and to carriage of contraband, the Bermuda. The court observed in the latter case, it makes no difference whether the destination to the rebel port was ulterior or direct, nor could the question of destination be affected by transshipment at Nassau if transshipment was intended, for that could not break the continuity of transportation of the cargo. A transportation from one point to another remains continuous, so long as intent remains unchanged, no matter what stoppages or transshipment intervene. In the Peterhof, the doctrine was carried to the farthest extent when the alleged ulterior destination of the contraband cargo was applied to land transport as well. The United States applied the doctrine of continuous voyage even to a blockaded port where there was an intention that the cargo after it landed at the neutral port was to be sent forward to the blockaded port by the same or another ship. Although the principles of continuous voyage were accepted in the main by the nations, there existed diversity of opinion with regard to the conditions under which contraband was liable to capture. The unratified Declaration of London of 1909 evolved a compromise whereby the doctrine of continuous voyage was fully maintained as regards absolute contraband, and it was declared that it was immaterial whether the carriage of goods was direct or entailed transshipment, or a subsequent transport by land, but it was not applied to the carriage of conditional contraband except in the rare cases where the ultimate destination was a belligerent country with no seaboard or coastline. The declaration, however, remained unratified, and during the two wars the above rule was flagrantly violated inasmuch as the doctrine of continuous voyage was applied to the carriage of conditional as well as of absolute contraband. In the First World War, the British courts extended the doctrine of continuous voyage much beyond the rule laid down in the Declaration of London. In the case of Kim, Sir Samuel Evans observed that the doctrine of continuous voyage, or transportation, both in relation to carriage by sea and to carriage over land, had become part of the law of nations at the commencement of the present war in accordance with the principles of recognized legal decisions, and with the view of the great body of modern jurists, and also with the practice of nations in recent maritime warfare. With regard to the partial immunity of conditional contraband articles granted by the Declaration of London, the learned judge disagreed with the compromise reached at the conference. It was also observed that contraband articles are said to be of an infectious nature, and they contaminate the whole cargo belonging to the same owners. The innocence of any particular article is not usually admitted to exempt from the general confiscation. B. Problem. The goods can be seized and the vessel condemned. The ultimate use to which cloth is to be put, namely, coats for the enemy, makes it absolutely contraband. The fact that it is first destined to a neutral port does not make any difference, for it is ultimately to reach Germany, and this makes the doctrine of continuous voyage applicable. In the parallel case of the Balto, to be, and CPC 398, similar decision was given by the British court. Q90. The principle of continuous voyage or ultimate destination shall be applicable both in the case of contraband and blockade. Ans. Continuous voyage applicable to contraband and blockade. The doctrine of continuous voyage, observes Hyde, often a device which was employed by the prize courts to frustrate evasion by neutral traders of belligerent prohibitions such as those forbidding participation in the colonial trade of the enemy, or the carrying of contraband to its territory, or the attempting to break a blockade of its coasts. The examination into the continuous nature of voyages, or may be necessary in reference alike to blockade, trade with enemies, a neutral service, and carrying contraband, and indeed, to all cases where the destination of the vessel or cargo is material. Examinations into continuity of voyages occur chiefly where a subject of the capturing power is supposed to be trading with the enemy, or a natural to be sending contraband goods to the enemy, or under what is called Rule of 1756. It also becomes important in case of suspicion of an intent to break blockade. If a cargo is destined to be carried through blockade, it can be captured at any stage of the voyage. A neutral destination will often be interposed in such case, with all the ceremonies of landing, transshipping, sale, etc., as in the case of contraband, and the same test and principles of reasoning apply to both. The doctrine has, therefore, been applied in case of prohibited trade, cases of blockade, and cases of contraband. The rule of war of 1756 enabled the belligerents to prohibit neutrals from carrying on a trade close to them in time of peace. As regards the application of the doctrine to blockade, it permitted the cargo to be captured at any stage of the voyage if the same was destined to be carried through blockade. With respect to contraband art, 39 of the Declaration of London provided that absolute contraband was liable to capture if destined to territory belonging to or occupied by the enemy or to his armed forces, it being immaterial whether the carriage of the goods was direct or entitled transshipment or even a subsequent transport by land. Q91. Write a short note on the rule of the War of 1756. Ans. Rule of the War of 1756. The doctrine of continuous voyage is generally regarded as connected with the application of the rule of the War of 1956, which enabled the belligerents to prohibit neutrals from carrying on a trade close to them in time of peace. During the 7 Years' War with England, France, finding that the naval superiority of England did not enable her to carry on her colonial trade, permitted the Netherlands, which was a neutral, to carry on that trade by license. The British government ordered the seizure of Dutch ships with their cargoes on the ground that they had incorporated with the enemy's merchant marine and were as such liable to capture. Shorn of all detail, the rule of 1756 expressed the practice in fact older than 1756 that the innocent but ordinarily closed trade in time of peace between one port of a belligerent and another such port, or between the mother country and one of her colonies, was not allowed by the other belligerent to be carried on by neutral vessels. Q92. A. Define blockade. What are the essentials of an effective and binding blockade? When does it terminate? Refer to leading cases. B. Is mere intention to break a blockade sufficient to incur condemnation? What would be the precise effect of proof that a ship has made a suspicious change of course to avoid man of war, or an unnecessary deviation from warranted course, or that it refuses to lie when notified to do so, on a charge of attempting to run a blockade? Ans. A. Meaning of blockade. Blockade is the blocking by men of war of the approach to the enemy coast or a part of it, for the purpose of preventing ingress and egress of vessels or aircraft of all nations. Oppenheim. The above definition brings out the following characteristics of blockade. In the first place, blockade must be by men of war, though it may be reinforced by other means. In the second place, only enemy coast or part of it or enemy ports are to be the objects of a blockade. In the third place, blockade may prevent ingress or egress or both. In the fourth place, blockade to be admissible must be impartially applied to vessels or aircraft of all nations. And, lastly, blockade is a warlike operation. Blockade is not to be confused with siege, which aims at the capture of the besieged place. Blockade intercepts all intercourse by sea. Essentials of real and binding blockade. The essentials of a real and binding blockade are as under. 1. Proper establishment. In order that a blockade may be valid, it must be established under the authority of a belligerent government or naval commander specially authorized to declare a blockade. 2. Effectiveness. The blockade must be duly effective. It should not be a fictitious or paper blockade, but should be maintained by a force sufficient to prevent access to the coasts of the enemy. This aspect of blockade was emphasized both by the Declaration of Paris, 1856, and the Declaration of London, 1909. There must be a real and pressing danger to vessels in any attempt to pass through. There is no unanimity as to the essential requirements for an effective blockade. The artiho Dr. Lushington observed in the Francisco, 1885, Spinks, 287, in the High Court of Admiralty that the blockaded place must be watched by a force sufficient to render the egress or ingress dangerous, or, in other words, save under peculiar circumstances, as fogs, violent winds, and some necessary absences. The force must be sufficient to render the capture of vessels attempting to go in or out most probable. Lord Chief Justice Cockburn observed in Gopal v. Smith, 1872, LR 7 QB 404, that in the eye of the law a blockade is effective if the enemy's ships are in such numbers and positions as to render running the blockade a matter of danger, although some vessels may succeed in getting through. 3. Continuously maintained. The blockade must be continuously maintained. When the blockading squadron is driven off by superior force of the enemy, it has been held that the blockade is null and defective from the beginning. The blockade will, however, not be impaired if the blockading squadron is temporarily withdrawn due to bad weather. 4. Notification. The Declaration of London laid down that in order to establish a blockade it is essential that it should be notified. The notification must be made either by a belligerent government or by a commander of a naval force acting on behalf of his state, and must specify the date when the blockade begins, the geographical limits of the coastline under blockade, and the period within which neutral vessels may come out. 5. Impartiality. The blockading force must enforce the blockade impartially against all vessels. Any relaxation of restrictions in favor of a belligerent to the exclusion of neutrals renders the blockade inoperative. In the case of the Francisco, the British blockade of Riga during the Crimean War against Russia was declared by the Privy Council to be invalid because relaxations were granted to belligerent merchant vessels to the exclusion of neutrals. 6. Must not bar access to neutral ports. The blocking force must not bar access to neutral ports or coasts. 7. No extension beyond the operation area. A blockade cannot extend beyond the aim covered by the operation of the forces which maintain it. Cessation of blockade. A blockade ceases to exist on the happening of either of the following contingencies. 1. On the termination of war. 2. When the government which instituted the blockade withdraws it. 3. When it ceases to be effective. 4. When the blockading squadron is defeated and driven off by a hostile force. 5. When it is withdrawn for a cause or an action, and 6. When the place or port under blockade is occupied by a victorious belligerent. In the case of Frederick Moltke, it was held that a vessel coming out of a blockaded port with a cargo was prima facie liable to seizure. In the Betsy, Sir William Scott observed that on the question of blockade three things must be proved. First, the existence of an actual blockade. Secondly, the knowledge of the party. And thirdly, some act of violation, either by going in or by coming out with a cargo laden after the commencement of the blockade. In the case of the price cases in Re. Hiavtha, it was observed by the United States Supreme Court that a vessel being in a blockaded port is presumed to have notice of the blockade as soon as it commences. In the case of the Zamora, Lord Parker observed that an order declaring a blockade will prima facie justify the capture and condemnation of vessels attempting to enter the blockaded ports, but will not preclude existence to show that the blockade is ineffective and therefore unlawful. B. Mere intention to break a blockade is not sufficient to incur condemnation. There must be some act of violation or an attempt to break the blockade. A suspicious change of course to avoid a man of war or an unnecessary deviation from warranted course may be taken as prima facie evidence of attempting to run a blockade. Refusing to lie when notified to do so would be even stronger evidence of an attempt to run a blockade. But in all these cases it must be near about the zone blockade. Q. 93. Define. A. Strategic and commercial blockade. B. Long-distance blockade. Ans. A. Strategic and commercial blockade. It has been indicated earlier blockade is an act of war through which the sea coasts of the enemy state are partly or completely blockaded. The chief objective of this is that supplies of FOC materials, etc. may not reach the enemy country so that the enemy may be defeated or may be compelled to accept the conditions of the other belligerent state. This is called strategic blockade. On the other hand, blockade may also be peaceful and commercial. A commercial blockade is one, the objective of which is to prevent sea coast of enemy for the purpose of trade. Commercial blockade, strictly speaking war. B. Long-distance blockade. Long-distance blockade was started for the first time in the First World War. It was a new method of blockade. During the First World War, Germany laid contact mines under the seas. In reaction to this, Britain declared North Sea as area of danger and laid contact mines in it. As a reaction to it, Germany declared the seas throughout the British island as war areas and declared that if the ship of any country entered that area, it would be destroyed. In reply to this, Britain declared that if the ship of any enemy state entered that area or its owners shall be enemies, it shall be destroyed. Consequently, both Germany and Britain adopted the new methods of long-distance blockade. Some neutral countries, the prominent among them being America, opposed this type of blockade and contended that it was not a legal blockade. Great Britain, however, contended that it was a legal blockade and argued that it was the blockade adopted under special circumstances. However, on the pressure exercised by America and certain other neutral states, The long-distance blockade was ended in the First World War, but it was again resorted to during the Second World War. Q. 94. A. State briefly the essential features of unneutral service and illustrate your answer by reference to some decided cases. B. A year after the outbreak of the last war, when Japan and the USA were both neutral, 10 Germans aged between 25 and 1935, 5 Germans between 1970 and 1975, and 8 Germans between 8 and 10 were coming to Japan on a Japanese passenger ship from New York. While the ship was in Japanese territorial waters, a British cruiser forced them to disembark and detain them. Discuss the justification or otherwise of the act. Ans. A. A neutral service. The term a neutral service denotes acts sometimes performed by neutrals which involve an entry for the time being into the service of a belligerent, and the doing for him what is of direct advantage to him in his war. Lawrence. Such a neutral service is rendered by neutral vessels by giving material assistance to a belligerent. The other belligerent state has a right to inflict on them a penalty varying according to the immensity of the unneutral act. The Unratified Declaration of London, 1909, declared for the first time a coherent law on unneutral service. Article 45 provided that if neutral vessel was on a voyage specially undertaken with a view to either a. the transport of individual passengers who were embodied in the forces of the enemy, or b. with a view to the transmission of intelligence in the interest of the enemy, the vessel was liable to condemnation if the service was rendered knowingly, though it need not necessarily be an exclusive service. But the vessel was not liable to condemnation if there was ignorance of the outbreak of hostilities or lack of opportunity for, however, discharging passengers after becoming aware of it. Article 47, however, provided that the belligerent cruiser might demand the surrender as prisoners of war of any individuals embodied in the armed force of the enemy found on board a neutral merchant vessel, even though there might be ground for the capture of the vessel, and the vessel may be allowed to go her way. Article 46 provided that unneutral services of the graver and more serious kind rendered the vessel and any goods on board belonging to her owner liable to confiscation by placing her in the position of a captured enemy merchantman. Such cases arose when a neutral vessel took a direct part in hostilities, or was under the orders or control of an agent placed aboard by the enemy government, or when the neutral vessel was in exclusive employment of the enemy government, or when the vessel was exclusively engaged in transporting troops or intelligence in the enemy interests. Case Law 1. The Orozembo. It was an American ship which during the war with Great Britain and Holland in 1807 was carrying senior Dutch military officers and to Dutch civil servants to Batavia under the orders of the government of Holland. In the course of the voyage it was captured by the British. It was held that the vessel was a transport ship which was in the service of the enemy and liable to condemnation. 2. Friendship. The American vessel Friendship was condemned in 1807 for having, under contract with the French government, U.S.A. to transport French military officers and marines. It was a vessel hired by the enemy for the conveyance of military be considered as a transport subject to condemnation. 3. The Atlanta. The Atlanta was a neutral ship carrying dispatches hidden in a chest from the government Isle de France to the Minister of Marine at Paris. These dispatches were being taken within the knowledge of the captain of the neutral ship was acquired by the British government. Both the ship and the were condemned by a British prize court, which held that of dispatches was a service, which, in whatever degree it existed, could only be considered in one character, as an act of the most hostile nature, and the vehicle in which they are carried must also be confiscated. 4. In the affairs of the Trent. The British Mail 8 was stopped on its way from Hubna to St. Thomas by a cruiser in 1861 during the American Civil War, and two of its Mason and Slidell, who were proceeding as envoys of the Confederacy to Great Britain and France, were forcibly removed along with their two secretaries. The United States contended dispatches were clearly contraband. The bearers or couriers who undertook to carry them fell under the same category. Great Britain, on the other hand, repelled the contention of U.S.A. by observing that the character and office of the persons captured did not make them contraband, inasmuch as they were being sent out as envoys to neutral powers, and the seizure was unjustified, as a neutral state had absolute right to maintain diplomatic relations with the belligerents. After protracted negotiations, the United States released the prisoners and the law of contraband was held inapplicable to their case. 5. SS China. In the well-known case of the SS China, which was an American mail and passenger ship sailing between Shanghai and American ports, there were in 1916 on board the ship several Austrian and Turk passengers who were bound for Manila. A British on inspection removed these passengers. The Washington government entered a strong caveat on the ground that the persons did not come within Article 47 of the Declaration of London, which only allowed the capture of persons belonging to the Army and Navy only. The British government replied that these persons were carrying on subversive activities, being engaged in the smuggling of arms. While this controversy had not yet settled, the United States entered war, and the prisoners were released. B. Problem. It is the case of a neutral vessel sailing from neutral port for a neutral territory with civilians on board the vessel, the civilians being of German nationality, and Germany and Great Britain being at war with each other. It was contended on behalf of Japan that as the vessel in question was sailing from a neutral port for neutral territory with civilians on board, it was improper for Britain to detain them. The rule laid down in the SS China and the affairs of Trent is that persons belonging to the armed forces of a country at war with another could be captured from a neutral ship even on the high seas. But there could be no justification for capturing the civilians. The British government pleaded that as under the German Army Code, every civilian from the age of 18 to 45 must bear arms for the country. The passengers in question must be treated as future combatants, and as such they were liable to capture. The contention was obviously untenable, as it was unfair to judge the fate of civilians before they had actually landed in their country and had been enrolled in the armed force. At any rate, the capture of Germans between 8 and 10 and 70 and 75 was altogether unjustified, as even according to the British contention, they could not be expected to render military service in the immediate future. It may be noted that similar facts arose in the case of the Asma Maru in the last war, and eminent jurists shared the view as noted above. Q. 95. Distinguish between I. Unneutral service and contraband, and 2. Unneutral service and hostile service. Ans. I. Unneutral service and contraband. Unneutral service essentially differs from contraband in the following respects. In the first place, as Lawrence points out, there is a difference in the character of the acts themselves. What takes place in cases of contraband is done purely as a matter of trade. Its subjects are commodities and its objects gain. In unneutral service, the acts are not acts of ordinary commerce. The predominant attributes are warlike rather than mercantile. In the second place, for legal confiscation of the contraband merchandise, enemy destination is essential, while destination is immaterial in unneutral service. In the third place, there is difference in the penalty also. Cargo is confiscated only in rare instances in case of unneutral service. In contraband, the noxious cargo is primarily confiscated and the vessel is condemned in aggravated cases. In the last place, Oppenheim distinguishes by pointing out that carriage of contraband need not necessarily, and in most cases in practice does not, take place in the direct service of the enemy, while in unneutral service carriage of persons and dispatches for the enemy usually take place in the direct services of the enemy. 2. Unneutral service and hostile service. The case would be of unneutral service where the service is only partial. Example, where the vessel was engaged in carrying military persons or dispatches concurrently with her employment partly of an innocent character. Article 46 of the Unratified Declaration of London, 1909, enumerates 4 instances of hostile service where the neutral vessel acquires enemy character and may be treated as such. They are I. When a neutral vessel takes a direct part in hostilities. 2. When she is under orders or control of an agent placed on board by the enemy government. 3. When she is in the exclusive employment of the enemy government. And 4. When she is exclusively engaged in the transport of enemy troops or the transmission of intelligence in the interest of the enemy. Q. 96. What do you mean by diplomatic agents? Discuss the classes of diplomatic representatives. Give a description of immunities available to diplomats. Ans. Diplomatic representation. Diplomatic agents are ambassadors residing in a foreign country as representatives of the states by whom they are dispatched. Lawrence says that the introduction of the practice of sending permanent ambassadors to reside at foreign courts is due more to statecraft than to utility. Classes of diplomatic representatives. The Congress of Vienna, 1815, classified diplomatic representatives into three classes, to which the Congress of Aix-la-Chapelle, 1818, added a fourth. They are as under in order of seniority of rank. 1. Ambassadors, papal legates, and nuncios. They are representatives of the person and dignity of the sovereign or head of the state accrediting them. On presenting the sealed letter of credence, they are entitled to public audience from the head of the state to whom they are accredited. They have also the privilege of negotiating with the head of the state personally. They have a right to be addressed as His Excellency. Only states enjoying royal honors can send ambassadors. 2. Ministers plenipotentiary and envoys extraordinary. They are not the personal representatives of the sovereigns or heads of their states, though they are, no doubt, accredited to them. They have a private audience from the head of the state when on their arrival at foreign capital they present the letter of credence. They have also no audience as of right with the head of state personally and are addressed as Excellency by courtesy only. 3. Ministers resident. They are accredited to sovereigns and rank below the ministers plenipotentiary and envoys extraordinary. 4. Charges d'affaires. They are accredited not by a head of state to another head of state, but by a minister of foreign affairs to a minister of foreign affairs. The diplomatic envoys sent by the Holy See are called papal legates or nuncios. The diplomatic envoys exchanged between the members of the Commonwealth are called High Commissioners. The distinction between the different classes of diplomatic agents is purely ceremonial, for all of them enjoy the same diplomatic immunities. Diplomatic immunities. A diplomatic envoy is deemed for the purpose of jurisdiction and control to be outside the territory of the state in which he really is. He is regarded just as sacrosanct as the head of the state that he represents and enjoys immunities to enable him to discharge his functions efficiently and in an atmosphere of absolute fearlessness. The immunities are founded on common usage and tacit consent of nations. Immunity from criminal jurisdiction. A diplomatic envoy accredited to a state enjoys absolute immunity from criminal jurisdiction, as he is in no sense considered to be under its legal authority. His person is inviolable, and the receiving state can only arrest or detain him in cases of necessity or self-preservation. Gillenborg case. If a diplomatic agent commits a crime, the only remedy open to the accredited state is to report the matter to his home government and demand his retail and punishment according to the law of his country. Personal safety. The person of a public minister is sacred and inviolate. A diplomatic agent may, however, be expelled and, if necessary, arrested for being sent home if he plots against the head of the receiving state or the state itself is guilty of conspiracy or espionage. Immunity from civil jurisdiction. A diplomatic agent as well as his is exempt from the local jurisdiction. Magdalena Steam Navigation Covey, Martin. He is free from local process as well as from personal restraint. No civil action of any kind can be brought against him in the civil courts of the accredited state. He cannot be compelled to appear in court and plead, but if he elects to waive his privilege, the courts will deal him as an ordinary citizen. By the law of nations, neither an ambassador, nor any of his train or commites, can be prosecuted for any debt or contract in the courts of that kingdom wherein he is sent to reside. Immunity of envoy's retinue. The retinue of an envoy consists of A. Officials and other servants of the legation. B. Wife, children and other members of his family living with him. C. His private servants. And D. Couriers. A diplomatic agent has complete immunity with regard to his person and that of his suite. The immunity, though in a lesser degree, extends to the ambassador's wife, children, his official staff, secretaries, interpreters, naval and military attaches, chaplain and servants, which are the necessary accompaniment for his comfort and convenience. Personal inviolability from the jurisdiction of the state, however, does not extend to visitors and dangers on of the embassy. The other members of the retinue of the diplomatic agents, such as official and other servants of the legation, also enjoy the immunity detailed above. But such privileges are extended only to those who are officially attached to the legation. The dependent relatives of the diplomatic agent living with him are also immune from the jurisdiction of civil and criminal courts and enjoy other privileges. As regards immunity of private servants of diplomatic agents, the practice is not yet clearly established. They are no doubt exempt from civil jurisdiction, but in criminal matters Great Britain claims jurisdiction if the offence is committed by servants outside the residence of the diplomatic agents. Courtiers or dispatch bearers being officially connected with the embassy are immune from civil and criminal jurisdiction. They have a special passport for their duties and a right to innocent passage through third states. Immunity connected with residence. The official residence of the ambassador, with goods and furniture, stables and carriage, is considered as though it is situate outside the territory of the accredited state. It is regarded as sacred and is exempt from the local jurisdiction. It is virtually held to be a portion of the accrediting state. In other words, the fiction of extraterritoriality is applied to the residence of the diplomatic agents. Exemption from taxes. The envoy is free from the payment of taxes levied upon his residence, as the receiving state has no jurisdiction over such residence. He is expected to pay the charges for sewerage, light and water taxes, but he cannot be compelled to pay the same since he is immune from legal process. Very often such taxes are also not charged from him. Exemption from seizure of goods. The ambassador cannot be sued for debts, whether contracted before or in the course of his mission. He is free from arrest and his furniture cannot be seized or attached for the same. Right to worship. An ambassador has the right of having a private chapel in his hotel according to his own religion. This is known as the droit de chapel. Freedom of communication. A diplomatic agent enjoys freedom of communication to enable him to discharge his functions properly. His dispatches are immune from local jurisdiction and censure, even in third countries. Vienna Convention on Diplomatic Relations, 1961. The General Assembly resolution adopted on 7 December 1959, inter alia decided that an international conference of plenipotentiaries shall be convoked to consider the question of diplomatic intercourse and immunities and to embody the results of its work in an international convention, together with such ancillary documents as may be necessary, and requested by the Secretary-General to convoke the conference at Vienna not later than the spring of 1961. The conference accordingly met in Vienna, Austria, from 2nd March to 14th April, 1961, in which 81 states participated. The Vienna Convention on Diplomatic Relations was signed on 18 April 1961. The Convention on Diplomatic Relations consists of a preamble and 53 articles. It divides itself into 4 parts. The first part, consisting of the first 19 articles, deals with problems of diplomatic relations in general, defines the terms used in the convention such as head of the mission, members of the diplomatic staff, etc., deals with the appointment of the staff of the mission, appointment of nationals of the receiving state and the size of the mission, and with the question of declaring the head of the mission or any member of the staff of the mission persona non grata. The second part comprises Articles 20 to 28 and deals with well-established privileges and immunities accorded to the premises of the mission and to its archives, such as inviolability, which includes means of transport of the mission, exemption from all national, regional duties and/or municipal taxes, etc., freedom of movement, freedom of communication, etc. The third part, comprising Articles 29 to 36, specifies the privileges and immunities, etc., to be enjoyed by a diplomatic agent as personal inviolability, inviolability of residence and property, immunity from civil, administrative, and criminal jurisdiction, exemption from security regulations, taxation and customs duties, etc. The last part of the convention, comprising Articles 48 to 53, contains final provisions on signature, accession, ratification, entry into force of the convention, etc. Besides the Convention on Diplomatic Relations, the conference adopted an optional protocol concerning acquisition of nationality and an optional protocol concerning the compulsory settlement of disputes. The conference also adopted, amongst others, 2 important resolutions. The first resolution affirmed the importance of the subject of special mission and recommended to the General Assembly of the United Nations that it should refer the subject to the International Law Commission for further study in the light of the Convention on Diplomatic Relations adopted by the conference. The second resolution, entitled Consideration of Civil Claims, recommended that the sending state should waive the immunity of members of its diplomatic mission in respect of civil claims of persons in the receiving state when this can be done without impeding the performance of the functions of the mission, and that, when immunity is not waived, the sending state should use its best endeavors to bring about a just settlement of the claims. The Convention represents a great stride in the field of the codification and development of the rules of international law on diplomatic intercourse and immunities, a subject which had hitherto been regulated by customary international law or by bilateral arrangements. Q. 97. What is meant by exterritoriality in respect of the personnel of diplomatic corps? Has it really anything to do with their territory? What is the exact basis of exemption? An English national is in the employ of the Chinese embassy in London. His name has been included in the list of employees submitted by the Chinese embassy to the British Foreign Office. The English national has not paid the local rates which every Englishman is bound to pay under the law. His effects have been attached in execution to recover the said dues. He pays the dues under pressure of the process. He files a suit to recover what has been extracted from him on the ground that he is liable to no process of the English courts. Will he get money back? Give reasons. Ans. A. Exterritoriality in respect of personnel of diplomatic corps. The principle of exterritoriality in respect of the personnel of the diplomatic corps means that some persons, though residing within the territorial jurisdiction of a particular state, and as such ordinarily citizens of that state, are yet to be regarded as immune from the application of the civil and criminal law of the state, and subject only to the law of the country to which they belong. The principle has nothing to do with their territory. The ambassador represents the person and dignity of his sovereign. He is the representative of the head of the state, and as such is entitled to the privileges and honors due to the head himself. The ambassador would not be able to attend to the interest of the country, which he represents, with perfect freedom and absolute fearlessness, if he were liable to be dealt with on par with ordinary citizens. This is the exact basis of his exemption. Modern public international law rejects the theory of exterritoriality and prefers rather the necessity of recognizing a full dignity in the state which delegates an ambassador. In other words, the state recognizes a parity of rights and privileges amongst themselves and concedes a perfect equilibrium of authority and of jurisdiction. Rose v. The King, 1947, 3 DLR 618. B. He is entitled to get his money back. He belongs to the suite of a duly accredited ambassador. The fact that he is of English nationality is immaterial, for the immunity is not governed by territory. As a member of the suite, he is not liable to pay any tax, and having paid it under duress, he may certainly get the money back. Q. 98. The ambassador of state F in New Delhi goes to see Taj Mahal in the embassy car driven by an Indian driver. on the way due to the negligence of the driver. Two Indians are seriously injured. Discuss if the Indian driver and 2. The ambassador can be sued or prosecuted in Indian courts for the accident. Ans. A diplomatic envoy accredited to a state enjoys absolute immunity from criminal jurisdiction and police action, as he is in no sense considered to be under its legal authority. If a diplomatic agent commits a crime, the only remedy open to the accredited state is to report the matter to his home government and demand his recall and punishment according to the law of his country. If, however, he conspires to overthrow the accredited state, he may be arrested for the time being so that he may be safely sent home in due course. Art. 31. 1. Of the Vienna Convention on Diplomatic Relations, 1961. As regards the Indian driver, if he is on the envoy's retinue, he will be exempt from any liability. But if he is not in the list of persons filed by the envoy with the Foreign Office, he will not be exempt from criminal liability. The law is that the immunities in the case of servants extend to the indoor and outdoor domestic servants, including chauffeurs and gardeners. It is usual for the envoy to deposit with the Foreign Office a list of such persons for whom immunity is claimed. If the driver has been engaged by the envoy only for the trip to see the Taj Mahal, he will not be sick. Q. 99. When can a state refuse to receive a particular person as an envoy? Ans. Can state refuse to accept diplomatic agents? The receiving state may refuse to accept diplomatic agents on the following grounds. I. If the appointment of a particular person as diplomatic agent is considered harmful for the receiving state. 2. If the diplomatic agent has by his declaration or conduct done some inimical thing. 3. If he is a citizen of receiving state. It may be noted that it is not necessary for the receiving state to assign any reason for refusing any particular person as diplomatic agent. But such a situation arises very rarely because in the recent times, before appointing a diplomatic agent, the receiving state is generally sounded. In case the receiving state shows any reluctance to receive any particular person as diplomatic agent, such a person is not appointed as diplomatic agent for the obvious reason that the main function of the diplomatic agent is to improve the relations between receiving state and the appointing state. Q. 100. When can a diplomatic mission terminate? Ans. A diplomatic mission may terminate on any of the following grounds. 1. Recall of the envoy by his accrediting state on account of rupture of diplomatic relations. 2. Fulfillment of the object of the mission. 3. Revolutionary change of government in either state, in consequence change of headship. 4. Death of the envoy. 5. Death or abdication of the head of either state. 6. Return of the regular minister to his post. 7. Change in the rank of the diplomatic agent. 8. War between the sending and receiving states. 9. The extinction of either state by merger or annexation. 10. Dismissal of the envoy by the sending or receiving state. 11. Demand for recall of the envoy by the accredited state on account of being obnoxious to the government of the country. 12. Request for passport on the ground of ill treatment by the receiving state, and 13. Expiration of letters of credence, if for a limited duration. Q101. Can a diplomatic agent waive or lose his immunity? Ans. Can a diplomatic agent waive or lose his immunity? As pointed out earlier, diplomatic agent may waive his immunity. For example, if he is called as a witness in a court of law and instead of claiming his immunity, he presents himself unconditionally in the court, it will be deemed that he was waived his immunity. He will thus lose his immunity. In such a case, he cannot subsequently claim immunity from the jurisdiction of the court. Article 32 of the Vienna Convention requires that waiver must always be express. The initiation of proceedings by a diplomatic agent or by a person enjoying immunity from jurisdiction under Article 32 shall preclude him from invoking immunity from jurisdiction in respect of any counterclaim directly connected with the principal claim. It is, however, provided that the waiver of immunity from jurisdiction in respect of civil or administrative proceeding shall not be held to imply waiver of immunity in respect of the execution of the judgment, for which a separate waiver shall be necessary. Thus, at the time of the execution of the judgment of the court, the diplomatic agent may successfully claim his immunity. Q102. State the different kinds of treaties and the rules concerning international law concerning their formation, termination, and interpretation. Ans. Treaty. A treaty is an agreement or contract entered into between two or more states whereby they undertake to carry out obligations imposed on each of them. Kinds of treaties. Oppenheim classifies treaties into lawmaking treaties and treaties concluded for any other purpose. Treaties classified according to the subject matter are treaties of alliance, treaties of guarantee, treaties of commerce, treaties neutralizing state, etc. Vattel classifies treaties as equal and unequal and real and personal. Then treaties may be distinguished as unilateral and bilateral, according as they bind one party or both the parties. There are also multilateral treaties which bind more than two states as parties. Treaties classified according to objects are political, commercial, social, and treaties of guarantee, neutrality, cession or extradition. Treaties may also be classified according to form as to whether they are permanent or transitory. The most perfect classification is to be found in that given by McNair, British Yearbook of International Law, 1930, which is as follows. A. Treaties having the character of conveyances. B. Treaties having the character of contracts. C. Lawmaking treaties which may be subdivided into 1. Treaties creating constitutional law, example, the statutes of the Permanent Court of International Justice, now the International Court of Justice. 2. Pure lawmaking treaties, e.g. the labor conventions negotiated by the International Labour Organization. 3. Treaties, akin to charters of incorporation, example, treaties which established the Universal Postal Union, 1874. Power to enter into treaties. A sovereign state which has not parted with any portion of its sovereignty either by confederation or treaty of alliance possesses full treaty-making power. The power of semi-sovereign states to enter into treaties with other states is limited and depends upon the nature of freedom that they enjoy. In the case of a federation, the Constitution defines the powers of the member states to enter into treaties with other sovereign. In the case of the vassal state or protectorate, the power of the vassal state or protectorate to enter into treaties with foreign states depends upon the freedom allowed to them by the suzerain of the protecting state. Conclusion of treaties. Consent of both the parties is necessary, although duress in international law will not invalidate a treaty. Immoral obligations imposed by treaties or treaties opposed to public morality are not binding on the parties. There is no specific form for the conclusion of treaties. An oral agreement between representatives of the states charged with the task of conducting negotiations and empowered to bind their respective countries is sufficient to have binding effect if it is the intention of the representatives to conclude a legally binding transaction. The enormous importance of the issues involved in such agreements, however, necessitates the compliance of formal requirements and reducing the agreements into a document. Each of the states conducting negotiation appoints a representative or plenipotentiary for this purpose. The two plenipotentiaries exchange their full powers before entering upon their task. They then proceed with negotiations and draw up a final draft for signature, which is affixed at a formal closing session. A treaty generally comes into force on signature, unless states desire to subject it to ratification. Ratification. It is an act of adopting an international treaty by parties thereto. In other words, ratification implies the confirmation of the treaty entered into by the representatives of the different states. So long as a treaty is not ratified by proper authority under the constitution of the country, it lacks the formal validity or sanction. Ratification of a treaty may be withheld on the following grounds. 1. If the representative or plenipotentiary has exceeded his powers. 2. If any deceit as to matters of fact has been practiced upon him. 3. If the performance of treaty obligations becomes impossible. 4. If there has not been consensus ad idem, i.e., there has not been agreement as to the same thing. Registration. After the treaty has been so ratified, it has to be registered at the headquarters of the international organization. Article 18 of the Covenant of the League provided that every treaty of international engagement should be registered with the Secretariat of the League and published by it as soon as possible. To the same effect are the provisions contained in Article 102 of the United Nations Charter. Termination of treaties. Treaties may terminate on any of the following grounds. A. On expiry of the specified period for which a treaty was concluded. B. When the main object of the treaty is fulfilled. C. By mutual consent of the parties to the treaty. D. Non-performance of certain essential conditions. E. When the obligations of the treaty become incompatible with the Charter of the United Nations. F. When a war breaks out between the contracting parties. G. When one of the contracting parties is extinguished by annexation or merger. H. Force majeure and impossibility of performance. I. The doctrine of Rebus Sic Stantibus justifies the avoidance of treaties when they are dangerous to the life or incompatible with the independence of the state. Interpretation of treaties. There is a striking similarity in the principles governing the interpretation of treaties and contracts. The various provisions are construed literally and grammatically, giving the words their ordinary and natural meaning, unless it leads to an obvious absurdity or an established custom or usage connotes a different sense. In such a case, the reasonable meaning should be preferred to the unreasonable by keeping in view the spirit of the treaty. If a treaty is drawn up into languages which give somewhat contradictory meaning, the interpretation which accords with the intentions of the parties and harmonizes both the version must be adopted. The Mavromatis case. A narrow interpretation is to be placed on the provisions of a treaty which curtails the sovereign right of a state. Where a document is ambiguous, it should be construed in such manner which may make it less burdensome to the person responsible for the burden under the treaty. Vienna Convention on the Law of Treaties, 1969. A convention on the law of treaties was adopted by the UN Conference in Vienna in May 1969, by 79 votes to 1, with 19 abstentions. The convention is a major work of codification and progressive development of the law of treaties and is the result of the efforts of the International Law Commission covering a period of about 20 years. It broadly reflects existing international law and practice on the subject of treaties. The final text of the convention consists of 85 articles, is divided in 7 parts, and covers the whole range of topics falling within the law of treaties. Article I-A, contained in the introductory part of the convention, comprising arts 1 to 5, defines the term treaty as an international agreement concluded between states in written form and governed by international law. The convention does not cover treaties between states and international organizations or between 2 or more international organizations. As regards capacity to enter into treaties, Art. 6 provides that every state possesses capacity to conclude treaties. Part 2 of the Convention deals with conclusion and entry into force of treaties, including reservations, arts. 6 to 25, Part 3 with the observance, application and interpretation of treaties, arts. 26 to 38, Part 4 with the amendment and modification of treaties, arts. 39 to 41, Part V with the invalidity, termination and suspension of the operation of treaties, arts. 42 to 72, Part 6 with certain miscellaneous provisions, arts. 73 to 75, Part 7 with depositories, notifications, corrections and registration, arts. 76 to 80, and Part 8 with final provisions, viz., signature, ratification accession, etc., arts. 81 to 85. The Vienna Convention on the Law of Treaties, termed by Richard C. Kearney and Robert E. Dalton as the Treaty on Treaties, does not approach perfection. The international legislative process remains much too primitive a mechanism to approach to perfection. The convention is, however, in an unspectacular and earthbound way, a giant step for mankind toward a world in which the rules of law will be not a dream but a reality. Q103. Discuss the importance of the Pact of Paris of 1928 in international law. Was it proper to charge the leaders of Germany in the Nuremberg Trial with its violation? Give reasons for your answer. Ans. Pact of Paris. The Pact of Paris, also known as the Kellogg-Briand Pact of 1928, was originally a pact between the USA and France, but in 1928 it was adopted by almost all the important states of the world. It was epoch-making inasmuch as it was for the first time that the states of the world agreed to renounce war as the instrument of national policy. The treaty, though renouncing war, did not define it, nor did it provide for any sanction behind its provisions. There was no authority to punish a state government committing breach of peace. Moreover, there was no positive agreement to settle disputes by peaceful means, except that the settlement of all disputes shall never be sought except by pacific means. In view of such loopholes, the treaty remained a pious wish and a dead letter. It was honored more in the breach than in observances. In 1931, Japan invaded China in Manchuria. In 1935, Italy invaded Abyssinia. Then there was the annexation by Germany of Austria and Czechoslovakia in 1939. The Pact of Paris remained a dead letter all the time till it was dug out from the lumber room when convenient for the victorious powers to set out on trial the Nazi leaders. In his book From Geneva to San Francisco, Norman Beatwich describes the pact as an international case, purely platonic, promising nothing for future. It embodied a solemn declaration of renunciation of war, but it was not backed with the will of the member states. It was improper to have charged the leaders of Germany with the violation of the pact in the Nuremberg Trial. The nations who were the victors had themselves been guilty of several breaches of it in the past. Q104. Is there a duty to ratify a treaty? What are the consequences of non-ratification of a treaty? Ans. Is there a duty to ratify? International law does not impose any duty upon a state to ratify a treaty signed by its representatives. It depends upon the sweet will of the state concerned whether to ratify or not to ratify a treaty. This is based on the principle of the sovereignty of the state. Every sovereign state is entitled to keep away from the treaty or to repudiate it if it so desires. Thus, under international law, there is no general duty imposed upon a state to ratify a treaty. Consequences of non-ratification of a treaty. If a treaty is to come into force only after ratification, and state does not ratify it, then such a state will not be bound by the treaty without ratification. However, as pointed out earlier, whether a treaty is to come into force after ratification or without ratification depends upon the intention of the parties. The practice of the state, however, shows that they do not regard themselves bound by a treaty unless and until they ratify it. Q105. What are the grounds for the termination of treaties? Ans. Termination of treaties. Treaties may terminate on any of the following grounds. A. On expiry of the specified period for which a treaty was concluded. B. When the main object of the treaty is fulfilled. C. By mutual consent of the parties to the treaty. D. Non-performance of certain essential conditions. E. When the obligations of the treaty become incompatible with the Charter of the United Nations. F. When a war breaks out between the contracting parties. G. When one of the contracting parties is extinguished by annexation or merger. H. Force majeure and impossibility of performance. I. The doctrine of Rebus Sic Stantibus justifies the avoidance of treaties when they are dangerous to the life or incompatible with the independence of the state. Q106. Explain the following. A. Pacta tertis ni nocent nec prosent. B. Pacta Sunt Servanda. C. Rebus Sic Stantibus. D. Jus Congens. Ans. A. Pacta tertis nec nocent nec prosent. It is fundamental principle of the law of contract that only parties to a contract are bound by the contract. Similarly, it is a general principle of international law that only a party to an international treaty is bound by it. This principle is expressed in a Latin maxim called Pacta tertis nec nocent nec sunt. This principle has been incorporated in Article 34 of the Vienna Convention on the Law of Treaties 1969. This principle is subject to certain exceptions contained in Articles 35 to 38. They are: I. Treaties which concern the right of the third party. Article 36. Under this provision, even third party can be conferred some rights under the treaty. 2. Multilateral treaties declaring the established customary rules of international law may bind even non-parties. Article 38. 3. Multilateral treaties which create new rule of international law may also bind non-parties. 4. Some universal treaties such as a UN Charter may apply to even non-parties. When a treaty imposes some obligation on a third party and third party accepts that obligation, then such a third state party becomes bound by that treaty. Article 35. B. Pacta Sunt Servanda. This principle means that states are bound to fulfill in good faith the obligations assumed by them under agreements. In its advisory opinion in 1922 on the designation of workers' delegation in the International Labour Conference, the Permanent Court of International Justice emphasized that the contractual obligation was not merely moral obligation but was an obligation by which, in law, the parties are bound to another. Later on, the International Court of Justice, in its advisory opinion in 1951 on the reservation to the Genocide Convention, stated that none of the contracting parties is entitled to frustrate or impair by means of unilateral decisions or particular agreements the object and raison d'etre of the Convention. This principle has been incorporated in Article 26 of the Vienna Convention on the Law of Treaties, 1969, which provides that every treaty in force is binding upon the parties to it and must be performed by them in good faith. See Rebus Sic Stantibus. The maxim Rebus Sic Stantibus means that when the fundamental or material circumstances under which a treaty is concluded are changed, then this change becomes a basis for the avoidance, change or termination of the treaty. This principle is known as doctrine of clausula. Rebus Sic Stantibus is based on the assumption that there is an implied clause in every treaty that provides that the agreement is binding only so long as the material circumstances on which it rests remain unchanged. D. Jus Congens. The provision relating to Jus Congens is one of the most controversial provisions incorporated in the Vienna Convention on the Law of Treaties, 1969. Article 53 of the Vienna Convention provides that a treaty is void if at the time of its conclusion it conflicts with a peremptory norm of general international law. A peremptory norm of general international law is a norm accepted and recognized by the international community of states as a whole as a norm from which no derogation is permitted and which can be modified only by a subsequent norm of general international law having the same character. Reference may also be made to Article 64 of the Vienna Convention, which is a corollary of Article 53 referred above. Article 64 provides that if a new peremptory norm of general international law emerges, any existing treaty which is in conflict with that norm becomes void and terminates. Article 66 provides that if, under paragraph 3 of Article 65, no solution has been reached within a period of 12 months following the date on which the objection was raised, any one of the parties to a dispute concerning the application or the interpretation of Article 53 or 64 may, by written application, submit it to the International Court of Justice for a decision unless the parties, by common consent, agree to submit the dispute to arbitration. This is undoubtedly a great achievement.